once again brought late.
What is the reason?
I haven't been apprised of the reasons, my lord, so we will try and look into that.
Okay. Yes, Mr. Mgumazulu, are you still...
Court, please, my lord.
Further questions? You're still on the oath, Brigadier?
Yes, my lord.
Thank you.
My lord, may I seek your permission or ask for permission for the witness to be taken back on the aspect of his knowledge about the docket 534 concerning possession of drugs in Phosphorus.
You want to cross-examine him again on that?
On that aspect.
Okay, fine, no problem.
Thank you.
As a court case, my lord, just before my learned friend proceeds.
Yeah.
Yesterday he undertook to find certain portions in the record.
I know.
To
show us on the record
the questions that he was putting to the witnesses.
So has he brought that record? Mr. Mgumazulu?
Yes, Lord, I've got
you brought it. He says he brought it.
Yes, yeah. But the first point, my lord, relates to the
vehicle.
The questions that he put to Sergeant Mukhani.
Yeah, Mukhani, yeah.
As to what happened on the 19th. He contended that Sergeant Mukhani denied that he was joined by
Jonathan,
the Ekurhuleni team.
Yeah.
And we just want to refer the court to the proceedings of the 7th of November, 7 November 2023.
2023.
Yes, page 20.
Page 20. Right.
From line 14.
Line 14.
Yes, 14.
14.
Yes, 14. To page up to page 22, my lord. Up to
page 22. So it's page 20 to 22.
Yes.
Yeah. Okay.
And we just want to briefly quote what Advocate Mgumazulu said. Mr. Mgumazulu, accused will come and tell the court that on the 19th, on the date the alleged confession was taken, he was assaulted by the Metro Police officers, including Mabena, who was in your company. Then he says the Metro Police officers who were present was Butelezi, Jonathan, Mabena. Then Sergeant Mukhani then replied, I do not accept that because I do not know anything about that. He would have informed me if you've been assaulted. And that was when I think the submission of counsel was based on this particular answer by Sergeant Mukhani that he denied that the SWAT team was present on the day in question. And on page 21, Sergeant Mukhani carries on. He says he was the driver of the car.
Right.
And Mr. Mgumazulu says, yes. This is line 3 on page 21. It is my instruction that as he was transported, a car parked next to a certain filling station, where he saw a board reflecting Alberton. Then Mr. Sergeant Mukhani asked, I want explanation of whether it was when we were still on our way to Morocco. Then Mr. Mgumazulu said, this is the version of the accused. And he said, you can pose questions to me. Then Mr. Mgumazulu at page 18 says, I agree that the bottom line is I'm putting the version of accused 2. He was stopped, or the Toyota Fortuner stopped next to a filling station, and that is when a short while a motor vehicle that was driven by Jonathan arrived. Then Sergeant Mukhani said that is not true. And counsel yesterday contended that Sergeant Mukhani denied the arrival of the SWAT team. But as we mentioned, my lord, that the cross-examination was based on the version that was put that the incident occurred on the 19th en route to Morocco Police Station. And that is basically the trend of the cross-examination insofar as the rest of the pages are concerned.
Kubeka ke umshushisi efunda lo yadaba lelo ubaba uMngomezulu wayelivezile izolo ngalesikhathi ebuza umnumzana uMkhani imibuzo kula ukuthi uye wamtshela ukuthi umangalelwa wesibini yena uthi uye washawa ngase garage ethize uSergeant Mkhani yena wakuphika lokho emtshela ummeli ukuthi ushawe amaphoyisa abuya ekuruleni Metropolis wakuphika lokho uSergeant Mkhani waphinda futhi ummeli wamtshela ukuthi imoto kaJonathan iye yafika ngaleso sikhathi ulaye ukuthi noSergeant Mkhani waqhubeka ephikisana nalo lolo daba manje izolo angithuma sesishayisa bekathe ummeli uzoza ngaloko bufakazi umshushisi uqala ngabo uthi nabu lokufakazi oyikuthi inkantolo iye yabuzwa ngey7 zika November nyakeni.
Okay, yes, Mr. Mngomezulu.
My Lord, the version put to Sergeant Mkhano relating to the assault on the 19th.
On the 19th?
On the 19th, it's not in dispute. Sorry, my Lord. It has been put to Sergeant Mkhani that on the 19th, accused number 2 was assaulted by the police. The continuation of the assault, it did not end on the 19th.
Even on the 20th, after having made the confession, he was still assaulted.
He was assaulted even on the 24th.
I see.
Yes.
Now, what would be the assault for? Because he's already made his confession.
That is the question to be answered by the state.
Okay.
Yes.
Was it ever put, sorry, I don't recall that evidence.
Yes.
Mr. Baloi, was it ever put that even after the confession was made, accused number 2 or Mr. Mngomezulu's client was again still assaulted?
Well, we remember that version insofar as accused number 1 is concerned,
yes,
but not as far as accused number 2 is concerned.
No, but we're talking about number 2.
Yes, yeah, I'm just saying that the continuation of the assault after the making of the confession that was put
in respect of accused number 1.
Yes, on
okay, fine.
Yes, on record. But
I will check that evidence.
Yes.
I will make a special note here with a red pen that there's a dispute between the state and the defense regarding what was put and what was the answer of Mr. Sergeant Mkhano. Any other thing you want to add, sir?
My Lord, the assault that was actually effected on the accused on the 24th was even after
the 24th of June. Which accused is that?
Accused number 2.
Number 2
was
after he had made a statement on the 19th
from the magistrate.
Okay. So what was the assault for, by the way? Can you remind me? According to him, your instructions, what was he assaulted for? Because they have killed him, these 5 guys.
That's correct.
To make a confession. And then he actually, as I recall the evidence, he doesn't make the confession. The statement of the alleged confession is written out for him. He's only told to sign it. Is that number 1?
That's number 2.
That's number 2.
Even number 1 is the same position, but
he also signed what was already written.
Was already, yes. Okay. In Diepkloof Police Station.
In Diepkloof Police Station and at the
accused number 2.
Court.
Accused number 2. That's why he said he was assaulted in Orlando East. When Brigadier Gininda came with
the written confession,
with the written confession, sitting on the back seat of the white BMW.
Then fine, I appreciate it.
Then the reason why the court is interested to know why was there any continued assault after securing the confession. This is what I'm going to
canvas.
Okay,
fine.
Court pleases, my
Okay,
lord.
okay.
My lord, may I, with the leave of the court,
Regarding the question as to whether it was put to the witnesses that accused number 2 was assaulted after the 24th, the only allegation was that after he made the confession to the magistrate, on the way to Jamestown, they stopped along the route and he was assaulted and forced to sign the confession. But that is on the day of the of the confession and not after that.
Yeah, I appreciate that, because on the day of the confession, the allegation is that he was forced to sign a written statement or alleged confession, which was presented to him for signature.
Yes.
You see, now after having signed it, was there an imputation that they even assaulted him after he had signed it? And I'm saying,
Yes.
that
No,
I never heard that,
no,
that imputation.
No, not after that.
Okay, fine. Is that how you recall the evidence system?
That's correct.
Okay, fine, yeah. Okay, continue.
With the leave of the court, may I refer the witness to the records relating to the offense Sergeant Mkhano referred to, the docket under 53406/2020. It's on page.
Do you have a copy of that record, sir?
No, I don't mean it.
Can you assist?
We have an electronic
Oh, I see, okay.
version. We'll just show it on the screen.
Okay.
Sorry, my lord, Mr. Ramsipit is not present today. He's going to assist me next to me. From page 37,
Yes.
the date is, I'll check the date now. November.
6 November.
The date of the 6th of November 2020. My lord, may I request my PA to come and sit next to me?
Yeah, fine.
Are you still looking for it? Yeah? Page 37 to 38. The last paragraph of page 37. Sir, are you in possession of the records?
No, I don't. I was told I'll watch it on the screen.
We'll print one for him just now.
Or may I give it to the interpreter? May I request the interpreter, my lord, to read for me?
Yeah,
It's going to be much
what you want to put
to the witness.
must be read
Yeah.
into the record.
Court, please.
Okay.
The last part, where it says Mr. Mgomezo, the last sentence of page 37 to the following page 38.
Mr. Mgomezulu. All right, now can you please give me the case number where accused was charged with possession of drugs? Should I read the response of Mr. Mukhani?
Yes, please. Up to the yellow.
This part.
Yes.
Mr. Mukhani, before what? Mr. Mngomezulu, possession of drugs. Mr. Mukhani, case number 278/6/2020. No, sorry. Sorry, 534/6/2020. The case number is 534/6/2020. Mr. Mngomezulu, so what is the charge under that case number? Mr. Mukhani, I remember that was the case. Mr. Mngomezulu, you are not sure. Mr. Mukhani, indistinct, not interpreted. Mr. Mngomezulu, sorry. Mr. Mukhani, let me say he was not charged. Mr. Mngomezulu, all right, the SAP 14A.
Just a slight correction, my lord.
Yeah.
On page 38, Mr. Mngomezulu put it to Mr. Mukhani, so was he charged, not what was the charge?
Okay.
Was he charged under that case number? And line 11, Sergeant Mukhani says, let me say he was charged. We just wanted to.
Okay.
Thank you.
I think the interpretation was that he was not charged.
Oh, but he was charged. That's the answer.
Yes.
Okay, fine.
Mr. Mukhani, after he was charged, Mr. Mngomezulu, all right, the SAP 14A notice of rights in terms of the docket 4534/6/2020, Mr. Mukhani, N in bracket indistinct, when the docket comes, Mr. Mngomezulu, so are you referring to this matter which was ultimately not placed on the court roll of phosphorus? Thank you. That is up until the yellow.
Thank you, my lord.
Yes.
So, Brigadier, did you understand the question that I posed on Sergeant Mukhani relating to the drug case in phosphorus?
Yes, I did, my lord. According to the record, if he's referring to this, I understand what was read to me, my lord.
Uzwile na umbuzo ongubuze umnumzana Mukhani uthi yebo nguzwile uma ingabe yiwo lo okhuluma ngawo.
So, is it your first time to hear, during the course of your investigation, to hear about that docket 534/06?
So, my lord, no, it's not the first time. What I said yesterday is the case reference number that I was not sure of, but I am aware that when accused 2, and I think I testify about it in my evidence in chief, that when he was taken to forced arrest, they wanted to put him with a matter that was pending. The case number I'm not sure because it's not my docket. Sergeant Mukhani is the IO, and that is the docket that I'm aware of. So if that is the reference number, then I'm aware. But also, my lord, in addition to, perhaps not in addition, I wanted to start there. Yesterday, it was put to me by defense for counsel, counsel for accused number 2, that the vehicle, this is now the Toyota Fortuner with VF47 LRGP, on the 24th. It was, I think there was a dispute in that regard.
Yeah.
I've checked my
Sorry.
records.
Sorry to
No,
interject.
Mr. Mngomezulu, please. Let him explain whatever he wants to explain.
mixing things here.
It was in dispute, my lord. And I
Yes,
was told
yes,
that
agreed.
the records will be brought to show that the vehicle was there because I've
Was the one
maintained-
that was being utilized
Indeed, and the vehicle indeed was at the police garage mechanical school.
in Benoni.
In Benoni on the 24th, my lord.
That's how I understand the evidence.
But-
The
with due respect-
AVL expert also said that.
With
Indeed,
due
my lord.
respect, my lord, I'm coming there.
No, I'm just
still
saying.
busy with what happened in Foslorus. May I not be disturbed, Brigadier? Okay. I'll come to that issue of yesterday, because yesterday you deny having knowledge of the docket of Foslorus under 534.
No. I was asked, but that's not correct, my lord.
Yeah.
I was asked specific about the case reference number, not that I was aware if accused was taken to Phosphorus to appear. That's not how it was put to me, my lord.
Okay,
so
fine.
That's not correct.
Maybe you can listen to the records from yesterday.
Yes, we can, my lord.
Yes.
Iyabuza ke ummeli ukuthi njengoba sekuchazwe ke le case number le eyase Phosphorus usathi wena awuyazi ukuthi njengoba sekuchaziwe ukuthi laliphi icala ngiyayazi le case number ukuthi nje izolo into bengingayazi bengingenaso iqiniseko sayo bekade kuyile case number ukuthi yaliphi icala kodwa ngiyalazi futhi bese sekachaza nokuthi imoto leyana iToyota Fortuner njengoba bese sekuthiwe bekade ihamba yena uyachaza ukuthi ngempela unesiqiniseko futhi nayizolo makabuyela ngemva kokuthi icala selimisiwe yena uye wayohlola wathola ukuthi futhi leyo moto le yayikade imile ngalelo langa le 24 kodwa umnumzana uNgomezulu uthi uzobuya lapho akalinde angamhambeli ngaphambili.
Say, I'm putting to you that you had a conversation with Sergeant Mukhane in relation to transporting of accused number 2 to Foslorus police station, or to Foslorus court.
When, my lord, if I may ask, on what date?
On the 19th.
Yes, we did, my lord. This is the day where I told Sergeant Mokhane that Lieutenant Colonel Rapadi is available. So they should start there in Moroka SAPS for the confession. Then I was aware that when they were done, they will be going to Fosoras Magistrate Court. I've said that in my evidence in chief. I've
Yes.
covered that aspect, my lord.
Uthi ngifuna ukwazisa ke ukuthi wena noMkhane niye nakhuluma ngalokhanjiswa kwamangalelo wesibini nge-19 uthi yebo sakhuluma ngoba bengikade ngimcebisa ukuthi sengimtholele uLieutenant Rapadi ngoba ubekade umangalelwa kwamele ayogunyuluka kuye manje besikhuluma ngalo lelo daba.
My concern is with reference to the evidence that you gave yesterday, denying knowledge. That's the reason why I had to go through my records. You deny having knowledge of the case against accused number 2 for drugs. Now I would like to refer you to another record where there was a conversation between yourself and Sergeant Mukhane.
My lord, I think counsel for accused 2 is misunderstanding. There was no denial that I'm aware that accused 2 was taken to court. That's not the question that was put to me. A question was put about a specific case number. I was given a specific case number that I was asked if I know it. It's not my case, so I couldn't remember from the top of my head. But the fact that accused 2 was taken to Fosoras Court, I'm aware, and I've testified about it in my evidence in chief. There was never a denial.
Uthi ke bengingaphiki ukuthi umangalelwa yena uyisiwe eFoslorus enkantolo into bengiyisho ukuthi icase number akuyona eyami manje bengingazi ukuthi eliphi lelo cala ekukhulunywa ngalo kodwa bengingaphiki ukuthi umangalelwa uyisiwe eFoslorus.
Thank you. What page is that, Mr. Interpreter?
Page 74.
Date?
Dated the 13th of November 2023.
Yes. where I've indicated it's a re-examination of Counsel Baloyi of Sergeant Mukhani.
And it states, Mr. Baloyi, yes, the outcome thereof is on then Exhibit MM. Can just put that in record again, the register, it is UU1. Mr. Mukhani, after placing him on the holding cells, I went to see the prosecutor and the matter was not enrolled on the court roll. Mr. Baloyi, yes, then what happened to the accused? Point number 10, Mr. Mukhani, we took him and left with him. Mr. Baloyi, yes, thank you. You were on the N3 freeway, Phosphorus at 14:06:35. When we left the court, Sergeant Mabena noticed that he left his memory stick and his keys at Moroka police station.
Yes. Thank you, Mr. Interpreter. This is the re-examination to confirm. May I address the court, my lord? My lord, the reason why canvassing the issue of the docket 534 is because the court also remarked that could not remember the docket of possession of drugs in Phosphorus. The court makes reference to the matter that it recalled for accused number 1, where Sergeant Mukhola was the investigating officer in that matter.
Okay.
Hence, I was going to request to listen to the records because I want to prove to the court that the witness, Brigadier Gininda, denied having knowledge of this docket. May I proceed, ma'am?
Well, he disputes it. He says he never denied. And I'll check what is the actual state. I'll make a note with a red pen that I should check the evidence on page of the 13th of November, page 74. Okay.
That's correct.
Fine.
So, Brigadier Gininda, according to your experience, as per your evidence, case number 2 was arrested on a charge of murder under case number 163 of Kwanongoma. And now it is apparent that there was a pending case in Phosphorus against number 2. So, is it your evidence that both matters were not placed on the roll on the 19th of June 2020 in terms of the records?
If I can seek clarity, my lord, which record is counsel referring to?
No, Mr. Gininda, we just read the record relating to the drug matter. And yesterday you testified about the matter that has not been placed on the roll under case number 163.
My lord, what was read to me, and that's why I asked the question, nowhere in what was read to me was there an indication that there's a pending matter. So that is why I wanted to get a clarity. Which part refers to a pending matter in Phosphorus? Because I did not hear that, so that I answer precisely. That's all that I'm asking. Because what was read to me refers to what happened in Phosphorus, not a pending matter. My understanding of a pending matter is a matter that is on the roll already. My understanding of the situation that took place on the 19th the matter of Kwanongoma, as well as the one that they wanted to add accused on. He was never accepted to be added there, hence the matter was never enrolled insofar as Nongoma 163 of 4/2018. That's what I know. I don't have an indication that he was enrolled in Phosphorus, and I don't have any information that there was a pending matter against him. That's why I wanted this clarity.
Bengidinga ukuchaziselwa ukuze ngizokwazi ukuphendula ngendlela efanele ngoba uma kukhulunywa ngokuthi kunaleli cala lase Phosphorus elingazange lifakwe enkantolo, mina bengidinga ukwazi ukuthi kukhulunywa ngaliphi icala ngoba kunaleli cala la kwaNongoma bese kuba naleli cala la sephosphorus leli eyukuthi la kwaNongoma kula umangalelwa angazange libe liyiswe enkantolo noma libiliswe phambi komantshi, ingakho bengidinga ukuchaziselwa ukuze ngizokwazi ukuphendula kahle.
Was it not your evidence that that matter was not placed on the roll, the Nongoma case?
Yes, it was not placed on the roll. That's what I said, my lord.
Thank you.
Ngisho njalo njengoba ungibuza ukuthi angishongo na ukuthi leli yaqala la kwaNongoma alifakwanga kwamantshi uthi yebo, ngisho njalo.
And the accused was in custody under that case, case number 163. Is that so?
Is it now?
Accused number 2, was he in custody, or that means he was arrested under that case number, that case number?
He was
Is that
here-
what we agreed on?
No, my lord, we agree, but you see, you must put it into a right context because
No.
after, no, can I explain, my lord? On the 16th, when he was arrested, I agree. He was in custody under Nongoma 163 of 4/2018. Up to the time he was taken to forced arrest, up for the magistrate court in forced arrest. Subsequent to that, later, he was then detained on a different case of cocaine. So if the assertion is that on the 16th to the 19th, he was detained under Nongoma case, yes, we're on the same page. But subsequent to his release, he was never in custody on the same case number.
Siyavumelana uma ingabe sithi kusukela nge-16 ukuyofika nge-19 umangalelwa wayekade evalelwe ngaleli cala la kwaNongoma, yebo lokho siyavumelana. Kodwa into esingavumelani ngayo ukuthi naleli cala leli lase Phosphorus silibandakanisa kuwo lawo malanga lawo kube kade sekavalelwe ngelinye icala.
Please understand me to say, accused number 2, when he was taken to Phosphorus police station, the case of cocaine at that time did not exist. Did not exist at that time. When a decision was taken by the SPP not to place the matters on the roll in Phosphorus, the cocaine case was not there, because a cocaine case followed after accused number 2 was taken to the place where he was renting a place. Do you agree, sir?
I agree, but also,
Yes.
but subsequent to the decision of the prosecution, my lord, of the SPP, that's what I'm saying, that after the matter was not enrolled, he was not in detention under Nongoma case. We're on the same page in that part. What I wanted to be clear is that there's no, because I understood the question to be saying he was in detention on the same case even after he was released. That's the part I wanted to be clear.
Bengifuna nje ukususa loludaba lokuthi sizwane kahle ukuthi ngemva kokuthi kuye wangafakwa enkantolo kuleli yaqala la kwaNongoma bese sekavalelwe ngelinye icala. Nangokho ummeli ethi lecala lasePhukeni lalikade lingakafiki ngoba umangalelwa wayekade engakayiswa kule ndawo la bekade eqashe khona.
Yes, my concern is immediately after a decision has been taken that they will never place those matters on the roll, was accused number 2, was he not supposed to be released because those matters were not placed on the roll? That's my question.
Well, my lord, what I know, they were pending investigations, and I think Sergeant Mahane can explain that better because I don't want to speak on his behalf. But what I do know, there were pending investigations that needed to be done insofar as this matter, the 636. But he was not in detention. Where he was placed under arrest, it's when the ammunition was found later.
Manje bekungamelanga na ukuthi umangalelwa wesibili ngemva kokuthi lamacala angafakwa enkantolo bekungamelanga ukuthi akhululwe na uthi ubrigadier uSergeant Mohani uyena ongachaza kangcono kodwa bekade kusaphenywa ngaleli cala u636 bese ke kulayi ukuthi ke kwavela futhi naleli yaqala lokuba neinhlamvu ezingekho emthethweni.
I'm putting to you that that aspect has been canvassed by Advocate Mshololo to Sergeant Mukhane in relation to the status of accused number 2 immediately after the disposal of such matters or after these matters were not placed on the roll. This is what Advocate Mshololo put to Sergeant Mukhane. Why was he not released? It's the same question that I'm posing on you. If accused number 2 was not placed on the roll in Phosphorus, why was he not released?
But he was released, my lord. When he was discharged to say the matter is not enrolled, he was released from the charges pending 163 and whatever that was being pursued on. From then, another investigation started that the police were following. It's a different, it's not a continuation. And my understanding, my lord, there is no provision that says if you are released on this matter, then literally the police must let you go if they want to pursue certain things and then start all over again on another day. He was with them. They felt that now that it's been disposed of, let this information of the would be followed. I don't see anything that was procedurally done, my lord.
Lolu daba othi uSergeant Mukhane uyena ongaphendula ngalo. Ummeli uMshololo uye wabuza ukuthi ngemva kokuthi lamacala angafakwanga enkantolo kungani umangalelo wesibini angazange akhulume. Brigadier mayiphendula mababuza yena ukuthi kungani angazange akhulume. Uthi uye wakhululwa kodwa ngoba bekusanophenyo ingakho uye kwahanjwa naye bese bekusaphenywa lelicala elehudi kulayi ukuthi umangalelwa akazange akhulu kodwa kulamacala lawayana njengoba angafakwanga enkantolo uye wakhululwa kulawa macala futhi uthi akazi umthetho othi uma ingabe umuntu kusaphenywa ngaye kwamele akhululwe bese bazobuya bamlande futhi ngemva kokuthi baqedile uphenyo.
That is the reason why we are going to place it before this honorable court and we are going to show this court that immediately after accused or during his arrest and after the matter was not placed on the roll, accused number 2 was still under unlawful detention. May I proceed? When accused number 2 was booked in back to Pretoria North, there's an occurrence book, I think it's MM, wherein he was booked back from investigation. May I confirm that, my lord? But I just want to reiterate on that. When he was booked in back to Pretoria North, under what case number was he booked in?
Can I have that exhibit, my lord, so that I can know what is written there?
When he was booked in.
Kuzwa ukuthi untanzi ngalesikhathi ebuyiswa ePretoria North yena wayekade evalelwe ngaliphi icala ngayiphi icase number usabhekwa laphayana.
On what date, my lord, perhaps if counsel can indicate what date is referring to?
I beg your pardon, I just want to confirm the OB, page 10. It's page 10. I took a little when we returned to is it page 10 or page 10? Page 10 of Exhibit MM.
What's happening?
My lord, we need to confirm the occurrence book on the 19th.
Yeah, where is the exhibit? Because you say it's exhibit MM.
Yes.
Where is it?
On page
Is that
10.
what you have handed over to the brigadier?
It's page 10 of,
Yeah, but this one, my lord, I don't think this is the right date. Because it refers to the 17th. The name of the
Sorry.
inmate is different. It's a different person for theft. It's not, it doesn't relate to accused to.
may the court bear with me, I have a side problem.
Why don't you put on spectacles?
No, they are aggravating the condition.
Is it?
Yes.
Because I know Clevers didn't want to put on spectacles.
No. They aggravate.
You see? Why, Mr. Mnisutlega? They used to say you're a moho if you put on
The
spectacles.
7th, I think I showed you. The 7th. On the bottom of the page.
Do you want me to adjourn so that you get your exhibits in order so that we know what we are doing? Because the brigadier
please.
says that exhibit is of a wrong case.
That one, my lord. But this one, the one that they give me the second time, it relates to accused number 2.
On the same date. Which date is
Well,
it?
it's the 19th of June.
Is that what you're
2020.
referring to?
That's correct.
19th of June.
Yes.
Okay.
To which police station was it booked in?
He was in Pretoria mode, my lord, on the 19th.
nge-19 ke uye wafakwa kwesiphi isitokisi kuthiwa ePretoria North.
But this entry, my lord, is not about the detention, it's about the charging. When they were charging him in preparation of the court, it's not about the detention, the one that I'm referred to.
Kodwa la lokho ngikufundayo akusiyi ngalesikhathi efakwa ummangalelo wesibini ngalesikhathi bemthwesa amacala.
So it relates to him being charged in respect of what? Which case?
I suppose, my lord, it will be Wanongoma, although here is blocked because somebody used a pen. But I know when he was there, I know that, my lord, that he was charged for the Nongoma case, the 16304/2018. And Sergeant Mohane was the one charging him. in
Is it
preparation
after
for-
now the prosecutor in Boksburg refused to place it on the roll? Or what?
No, this is the morning, my lord.
The morning,
4:35,
okay,
when
fine.
they were preparing to take him to court.
Okay,
on the
fine.
19th. Yes.
Okay.
Nangokho kungabonakali ngoba kunala kunomuntu esule ngepeni kodwa ngiyacabanga ukuthi la wayekade ethweswa leliya cala lakwaNongoma bekusekuseni utathabusa ngo 25 to 3.
I request to an adjournment. my lord.
Yeah, we
Just-
need that because
Yeah.
we don't know what's happening.
Yes.
Ngicela sibuye ngemva kwesikhathanyana.
Unikezwe abantu.
up.
Yes, Mr. Mgomezulu.
Thank you, my lord.
Yeah,
Thank
Bob.
you very much for your indulgence, my lord, to stand and step down. Mr. Brigadier Gininda, let's just proceed. May I just start? I just want to understand, when the confession was taken on the 19th now of June, was it taken in the morning or in the afternoon?
It was taken in the morning, my lord.
Ukugunjuluka laphayana nge-19 zika June kwayenzakala nini emini noma ekseni uthi kwayenzakala ekseni.
When were you in possession? When were you given the documents relating to the confession? Was it the same day or day after?
No, it wasn't the same day. It would have been maybe a day or 2 days. I had to go to Lieutenant Colonel Rapado's office in Enadine to collect the confession form, my lord.
Unikwe nini ke leliya phepha? Walinikwa ngalelo langa noma nini uthi bekungasingalelo langa ngoba mina ngiye ngafanele ukuthi ngiye enkantolo yaka Lieutenant Colonel Rapado.
All right, I'll get into the confession part. But what I want to check is when the matter was not placed on the roll in phosphorus in the morning after the alleged confession was taken, was it your decision to direct Sergeant Mkhane and Sergeant Mabena to take accused number 2 to Rustenburg?
No, so let me start here, my lord. The confession was taken in the morning. The matter was not enrolled, I think, around afternoon.
Yes.
So when they were done, I think it was around 2 or so afternoon. Then the decision, my lord, I wouldn't say it was my directive, because what I know, I was made aware of the outcome and the fact that they needed to follow up on other investigation relating to accused number 2. And in addition to that, then the issue of the wood. That is why then I said I will meet them in Bukeng, my lord. So it was not one incident. Sergeant Mkhane was sitting with a number of dockets that he wanted to follow also in that province. And then this one, the issue of the wood, then became also part of that. And I then said I will meet them in Bukeng police station, my lord.
Bekuyisinqumo sakho na sokuthi umangalelwa ayisiwe ePhukeng uthi cha kwakungasisinqumo sami uSergeant Mkhane wayekade enamanye amadokodo abekade ewaphenya ehlanganisa nalo leli futhi kwavela nalendaba lehudi ingakho ke bagcine sebaya ePhukeng ngathi mina ngizohlangana nabo ePhukeng.
Now the issue of the hoodie, I cannot assume that it came up after a confession has been made. I'm concerned about after the matter has been withdrawn. was not placed on the roll. So the accused was not going to be released in any event according to your evidence because of those dockets that Mkhano had.
No, my lord. So the accused was released insofar as the matters that he was detained for. What then transpired after he was released, you can call it an interview, and it happens all the time, my lord. For example, people get involved in accident-related matters. They could call to the police station as suspect when they know very well that perhaps you may have been negligent. They will take a warning statement. That is an interview. You will be released. It doesn't mean that when you are interviewed on a specific matter, while you are with the police during that period, you can call it detention because you are with the police, but there's still a decision that the police, if they feel at that moment they can't move on you, then they will release you. It happens. So what transpired after the docket was not placed to the time when the second date kicked in, it was an interview on various matters and the cooperation that accused was giving. It wasn't a detention, because if it was a detention, then charges would have been set to him what he's being detained for and would have been processed accordingly. It was a continuation of interview that started while he was in detention, because when I was following, my lord, an alibi that he gave us on the 18th, which said he was at work, that was part of the interview. It was not a detention. When I was with him, we went to his work. He was not in detention for this matter. It was an interview. We followed that alibi. It didn't materialize. So it was a continuation of interviews insofar as the hoodie and whatever the Sergeant Mkhane was following, my lord.
Ngemva kokuthi ummangalelwa lamacala lawa yanangafakwa enkantolo, yena uye wakhululwa kodwa ubekade esahlonywa imibuzo. Kuyaye kuyenzeke umzekelo nawo ukuthi umuntu uma engaba kwingozi yemoto, lo muntu lo uyayabizwe ahlonywe imibuzo ukubheka ukuthi bekubani obekade enze iphutha, nalokho mhlawumbe lo munye uyena obekade ebudedengu. Kodwa ke ummangalelwa naye wesibini ubekade ekhuluma esebenzisana nathi njengoba wayekade ebuzwa imibuzo, kube wayekade engabaza kula ukuthi ubekade ezokuthweswa amacala ukuthi leliphi icala ekuthi usowuthweswa lona ke sesikuvalela ngenxa yaleli cala, kodwa ngenxa yokuthi wayekade esebenzisana nathi ekhuluma uma silibele simbuza imibuzo, kungakho siyasambuza leyo mibuzo kwathatha naleso sikhathi. Kodwa ngaleso sikhathi wayekade engakavalelwa, wayekade nje ebuzwa imibuzo, ngakho kugcine sekuthi kuvela naleliyana lasephukeni.
When it comes to interviewing a suspect, taking you back to the alibi that you had to follow up on, was there anything recorded, especially from the 18 when you interviewed accused number 2? Did you record the rights that you have explained to accused number 2? Did you record the conversation between you and accused, or any kind of admission?
My lord, I did make entries on my diary. I might not obviously, because it's the diary, you summarize, and the copies which have been made to the defense is very clear of what was followed, and the fact that he made confessions, my lord. And I gave the defense the copy of the diary of the 18th.
Bukhona la ukuthi kuye kwabhalwa khona noma kwayenzwa into ekuthi ibekade izobonisa ukuthi bukade ukhuluma nommangalelwa wesibini, uthi yebo ngabhala kwi-diary yami, nangokho ngabhalanga yonke imininingwane ngenxa yokuthi kwi-diary uyaye ubhale nje into encanyana ukuthi kwenzakeleni, futhi leyo diary ibanikile abameli.
All right. Accused now is released from Phosphorus Court. He is now conveyed to Rustenburg. You said it was not your instruction to take him to Rustenburg.
I'm saying, my lord, I was aware. So if the position I was sitting in, I'm a commander. So obviously I didn't say they mustn't do it, because I believed what they were embarking on was a legitimate follow-up or work-related issues. I was aware they were going there to follow up on what Sergeant Mkhane had insofar as the other investigations. And in addition, then the issue of the hoodie came up. That is why I had interest. My interest was simply on the hoodie because it relates to this matter. The other matter, Sergeant Mkhane, is something that you could deal with.
Nganginolwazi ukuthi ummangalelwa kwamele athathwe ayiswe ephukeni, ngenxa yokuthi mina ngingumphathi ngiyengabona nokuthi bebakade bayenza into ehambelana nomsebenzi futhi uSergeant Mukhani wayekade enamanye amacala awaphenyayo kodwa kuye kwavela nalo daba lwehudi ingakho ngiye ngathi ngabona ukuthi bekulungile ukuthi baqhubeke ngalokho ngoba bebakade baqhubeka ngomsebenzi wabo.
So when you Sergeant Mukhani proceeded, and which came to your knowledge that they went to Rustenburg, was there any warrant of search that was applied for?
No, there was no warrant of search that was applied for.
Manje ukuya kwabo ephukeni baye bafaka isicelo sencwadi egunyazayo ukuthi bayokhuthuza endaweni ethize uthi cha beyingekho leyo ncwadi leyo akuzange kufake nesicelo sinje.
So you wouldn't be surprised why accused number 2 was acquitted at Tlhabane court due to the fact that there was no warrant of search, among other reasons why he had to be acquitted, among other reasons.
Yeah, my lord, so no one knew that in his residence, insofar as I know because I was there, although I didn't go inside, the local police and my investigation team went inside. We didn't go there to look for ammunition. No one knew that ammunition would be found. It just so happened that when they were looking for the hoodie, then ammunition were found. And in that matter, in booking, that's why I didn't testify. I didn't submit a statement as well. So I don't know what reasons were given to make the court come to that decision. But yes, it was acquitted. But I think that's justice. You have to prove your case beyond reasonable doubt. But I was not there. I was not part of those proceedings.
Kumele ke yisona isizathu esenza ukuthi umangalelwa aye watholwa engenacala kulela cala lase ke uthi ke ubrigadier mina angizange ngingene phakathi njengoba bekade ukukhuthuzwa kuye kwangena amaphoyisa wakhona laphayana na lethimba lami ebengikade ngihamba nalo mina futhi angenzanga istatement nangalesikhathi siya besingazi ukuthi kuzotholakala inhlamba thina empeleni besithi siyofuna leya hudi angazi ukuthi eziphi izathu einkantolo yaphana ngazo ukuthi umangalelwa ukhululwa ngenxa yazo.
As we speak, this is what I also put to Sergeant Mukhani. As we speak, accused number 2 is facing this charge of murder under 636. That's the only matter against him at the moment.
Well, when you say this is perhaps the right context, my lord, it's the only matter that has been enrolled. But if you ask, is the only investigation that is facing, there are numerous of them, my lord. But yes, the only matter that is on the court roll, it is this matter.
Njengoba sikhuluma kwamanje umangalelo esibini yena ubhekane nalecala lodwa elika 636 leli lokubulala uthi ubrigadier njengoba sisakhuluma kwamanje yilona lodwa elisafakwe enkantolo kodwa akhona amanye amacala ayikuthi kwamele asazofakwa enkantolo noma asapheli.
All right, let's get into the confessions part of my questions. Have you taken a confession before?
Oh yes, I have, my lord.
Wena usuke brigadier wathatha istatement lesi umuntu ekhuluma egunuluka uthi yebo.
Did you obtain a special training? Did you undergo a particular training relating to the taking of a confession?
Yes, especially the police training you undergo that, my lord, did explain. But I've also learned that at university, when you study law and law-related issues of confessions and so forth, it's covered there, my lord. That's evidence. It's part of the legal studies, my lord.
Uye waqeqeshwa na uthi yebo njengephoyisa siyaye siqeqeshwe futhi mina ngafunda lokho njengoba ngifunda umthetho. Uma umuntu efunda ezomthetho uyaye aqeqeshwe nangayo le ndaba leyo ukuthi kubhalwa kanjani noma umuntu umbona kanjani uma ikuthi uyagona.
This question that I'm going to ask relates to accused number 1 and number 2 about the requirements or the process or the procedure of taking a confession. When you're taking, like as the lead investigator in the Senzo Meyiwa case, all right? it come to your attention that accused number 1 or accused number 2 wants to make a confession, was it the right step to phone Mboto or to yes, you said you looked for somebody independent to take a confession. Ultimately, you got Mboto who took a confession.
So the question is, was it
The
the
question
right thing?
is it the right procedure that Mboto was supposed to take a confession after he had a discussion with you?
Yeah, my lord, I'll start with the last part, the discussion. The discussion between myself and Colonel Mboto was not about the merits of the case. It was a request to say, can you assist in taking the confession, not discussing the matters of the case. That is why I indicated that he was independent because he did not work on this case. We never shared this information. It was someone independent. So that's my answer to the last part. But going to the first part of the question, my lord, yes, it is procedural, my lord, that when confessions, if you are involved in the matter, it is more reliable. It's a best practice, my lord, that you try and find someone independent to actually document that confession. Because, for example, I was a commission officer even then, but if I take it, you know the merits of the case, it's not neat. I think it's just a way, it's a best practice that is suggested that someone independent should be the one taking the confession. But obviously the sparking point or the starting point starts with me, because before you call this person, you have to certify yourself that the person you are interviewing is willing to freely, voluntarily, and without any undue influence to make such confessions, and is aware of his rights. Then you move on to the independent person.
Le mibuzo elandelayo ngizoyibuza ngibuza ngaye umangalelo oqala nowesibili, isikhulukazi loludaba lokuthi nina benithi bayazithula kunezinto ebekade bezikhuluma. Manje umbuzo oqala ukuthi uthathe indlela elungile na yokuthi uze ushayele uKennel ukuze akube uyena oyikuthi ozothatha lezo statement. Uthi yebo, mina ngibona ukuthi ngithathe indlela elungile ngoba uKennel wayekade engasebenzi kulecala, futhi asizange sikhulume ngemininingwane yalecala, futhi yena wayekade engazi lutho ngalecala, bekuwumuntu ozimele phecelezi independent, la ukuthi vele kwamele kube umuntu ongazi lutho ngecala. Into yesibili, mina angizange ngaxoxa noma ngakhuluma naye uKennel ngalolu daba ukuthi nayi into engicela ukuthi uyiyenze ukuthi lo muntu uzothi ethi asizange saxoxa nokho.
According to your evidence, I doubt that you did not disclose the merits of the... I'll demonstrate why I'm saying that. I doubt that you did not discuss the merits of the case with Mboto. The reason being that, based on the question that I asked you, was Mboto a commissioned officer in terms of the procedure, being an independent person, qualified to take a confession from Mr. Spear? That's the question I'm asking. Was he not supposed to appoint another person?
No, I disagree. I totally disagree, my lord.
Yes.
So the last part, no, I did not, and I maintain that position. I did not discuss this case and what accused two intended to say. That's an elephant. I wouldn't do it, my lord. I didn't do it. Secondly, Colonel Mboto, then he was a colonel. A colonel is a commissioned officer. And Section 217 is very clear, my lord. He's a justice of the peace. He's a commissioned officer, and by the virtue of his position as justice of the peace, he is allowed to take confessions.
uKennel Mboto wakade kuumuntu onelungelo na lokuthatha lesi statement besikade sizokhuluma umangalo lokuqala. Uthi yebo, ngoba yena wakade kuyi-commission eyikuthi uma umuntu kuuKennel uyanikwa nalawo malungelo wokuthi angahle athathe inkulumo ezifana nalezo. Into yesibili, uthi ubrigadier yena uyaphinda futhi uyafunga uyagomela ukuthi akazange akhulume noKennel ngalolu daba ukuthi umangalelwa uzokhuluma nalo udaba oluthize.
My lord, sorry, Council. My lords, commissioned officers in the SAPS rank structure start at the rank of a captain. That's the first rank. Then you get majors. Then you get lieutenant colonel. Now you don't get majors. Then you get the colonel, the rank of colonel Mboto, who is a middle manager. He's part of the, the senior management at that level. So he's quite someone quite senior in the police, but he is regarded as a commissioned officer.
Manje ke umuntu oyikuthi ubizwa i-commissioned officer esikhwayiseni umuntu oyikuthi uqala ku-captain bese ngalesa sikhathi esidlulile bekunabo major bese uthola lo okuyi-position eyaka-colonel. La ukuthi u-colonel wayekade enalo igunya lokuthi angathatha leso statement.
I understand. I'll get into. I'm glad you mentioned the and you explained what is the justice of the peace and the quality or the credentials that Colonel Mboto had in taking a confession. But I'll still maintain that he was not a candidate, not in terms of the credentials, in terms of the procedure. Before you proceed on that answer, is it fair for me to proceed on another question relating to what you were saying about Section 217?
Yeah, but before, my lord, let me answer the part that the council has raised to me. I disagree. Colonel Mboto, the only criteria he needs to meet is that he must be an officer. He was a colonel far past the rank of a captain. He was a colonel, and as a result, by the virtue of that rank, it allows him to take a confession. That's all you need to prove them. You simply have to be an officer. Automatically, you are then allowed to take the confessions, any confession.
Into eyikuthi umuntu uyayidinga ukuze akwazi ukuthatha istatement salomuntu ogunyulukayo ukuthi umuntu kwamele abe uKenneth la ukuthi bese sekudala uKenneth edlulile kubukapteni manje yena wayekade enalo igunya lokuthi angahle alalele aphinda thathe statement esifana naso lesi.
So in relation to Section 217, my lord, I'm not sure if it will be prudent to ask about the interpretation of the provision to this witness because he seems to be knowledgeable about the law. If the court is
Are you disputing that Colonel Mboto is not authorized?
I'm not disputing that.
So this exercise is about what? Because why I'm asking this, Ramo CPD never queried the credentials of Mboto.
My lord, I'm not querying the credentials.
No, I'm just saying.
I'm saying Mboto in terms of the procedure. After he received an information from Brigadier Gininda that somebody wants to make a confession, he was not supposed to take a confession. That's what I'm saying. Colonel Mboto, according to the procedure, was supposed to get an independent somebody who was going to meet with the person who wants to take a confession independently without knowing the because.
So wait. If I understand you well, this gentleman, Brigadier, you are entitled to take confessions. Is that not so?
That is so, my lord.
Right, but because you personally, as I was listening to you, but because you are personally seized with this letter, you wanted an independent.
Correct, my lord.
I may just mention that there's nothing debarring the law from you to take that confession.
Yes, my lord.
You know that.
I know that.
It's just best practice and it's advisable. The case, it's a Natal case, Kruger.
Yes.
The judge was I'll remember the judge. So, best practice says, give it to another person.
Yes, my lord.
And now you give it to a colonel.
Correct, my lord.
Now, the supposition or the assumption or the assertion by Mr. Gomezu is Mboto must get another commissioner.
That's correct. My
Is that
lord,
the procedure, sir?
No, that's absolutely.
Or the law? Is it the law also?
It's not the law.
Okay.
It's not the law, and it's not even the procedure that is being followed, my lord. He's a commissioned officer. He's independent, and then he agreed to assist, my lord. I've taken confessions, I've been approached before, and it's the same principle. If I don't have any knowledge on the matter, and then I'll assist my lord.
Firstly, I'll disagree with the court and the witness on the basis that Colonel Brigadier Gininda, his credentials, yes, he can take a confession. But if he is a person of interest, he cannot take a
How
confession.
is he a person of interest? I'm quoting you a SCA case.
My lord, is
I used that case about 20 years back. And it's still the law. Okay, we can differ about that. It's still the law.
I'll make
just that
submissions.
it is advisable and best practice. There's best practice that because you assist with the matter, you must not take the confession. But there's no law disbarring you. But we can argue about that until pit.com.
Yes. Yes, ma'am. May I proceed?
Yes.
Yes. In relation to text, section 217, especially where it deals with the justice of peace. And that justice of peace, according to the provision, it relates to the person conferred with such powers under section 334 of the Criminal Procedure Act. Have you read that provision?
No, I've not, my lord. The essence of what section 217, my lord, I know. It's only the judicial officials that can take the part in justice of the peace, whom police officers, who are commissioned officers, falls under that category. Colonel Mboto is justice of the peace. He's a commissioned officer. He had a right, a legal right for that matter, my lord, to take the confession.
Okay.
He was legally qualified to do so.
Yeah, okay.
In terms of the provision, I'll just, because I have, my lord, a defense witness that will come and...
No, fine, you can argue that.
Yes,
Because you two are arguing about the law.
yes.
So you can prove it by by whatever means. Okay, no problem.
And
As a court, please, we just want to point out the section 334 relates to the appointment of
334.
yes persons as peace officers, not
Just
as,
read it to us
not as justice.
so that we
of the
get
peace.
educated.
It's fairly long section.
No, read it, sir.
The headings: Minister may declare certain persons peace officers
Right.
for specific purposes. Subsection 1A, the minister may, by notice in the Gazette, declare that any person who, by virtue of his office, falls within any category defined in the notice, shall, within an area specified in the notice, be a peace officer for the purpose of exercising, with reference to any provisions of this Act, or any offense or any class of offenses, likewise specify the powers defined in the notice. Subsection B, the powers referred to in paragraph A may include any power which is not conferred upon a peace officer by this Act. And subsection 2A, no person who is a peace officer by virtue of a notice issued under subsection 1 shall exercise any power conferred upon him under that subsection unless he is at the time of exercising such power in possession of a certificate of appointment issued by his employer, which certificate shall be produced on demand. Subsection B, a power exercised contrary to the provisions of paragraph A shall have no legal force or effect. Then subsection 3, the minister may by notice in the government prescribe A, the conditions which shall be complied with before a certificate of appointment may validly be issued under subsection 2A. Subsection B, any matter which shall appear in or such certificate of appointment in addition to any matter which the employer may include in such certificate. Then lastly, subsection 4, where the employer of any person who becomes a peace officer under this provision of this section will be liable for damaging arising out of any act or omission by such person in the discharge of any power conferred upon him under this section. The state shall not be liable for such damages unless the state is the employer of that person, in which event the Department of State, including a provincial administration in whose service such person is, shall be so liable.
Okay. So, sorry, so the criteria is the appointment
Yes.
The appointment.
by the minister or the authorized
Yes.
person.
Yes.
I mean, just place it on record that Mboto produced, I don't know if you're there, he produced this certificate of appointment. And this evidence was basically that he showed his certificate, Mr. Mnisi, you can correct me if I'm wrong, to the accused, before whom he was about to take a confession, and explained to him that I'm the justice of the peace. Here is my certificate of appointment. That's the evidence. And at that stage, Ramapsi PD never brought that argument. But you can bring it at any time to say Mboto had no lawful authority to take the confession.
My Lord,
Then you can argue the matter. Okay, no
that's
problem.
correct. May I just place this on record?
Yeah.
When I came on board
Yeah,
on the evidence of Colonel Rappard,
yeah.
this is what I've advanced.
Yeah, that's
To the
fine. I'm
witness.
talking about Mboto.
And he talk about a certificate which he got from Ria Pierre,
Yeah.
something like that.
Okay.
There's that evidence.
Yeah.
But what I want to place on record is that what incapacitated Section 1 of the Justices of the Commission and Commissioners of Oath Act. I forgot the act and the year in which it was promulgated. But Section 1 of the provision, it expressly states that the Justice Minister appoints a Justice of the Peace and issues a certificate after the appointment. The Justice, in terms of that, but in terms of Section 217, read with Section 334, this is the National Commissioner that appoints. You see the difference? In terms of Section 217, read with Section 334, Criminal Procedure Act, is the National Commissioner that appoints the Justice of the Peace. If I may remind the court about, sorry my lord, I used to...
Why don't you argue this thing? Because Mr. Brigadier Gininda has told you what he thinks he knows, what a commissioner of Justice of the Peace is. And you are educating him that, no, you're actually wrong. Then you can leave it for argument, because otherwise you are at university, all of you. I don't know what you're trying to prove. He says he knows that his Mbodlo was the Justice of the Peace. Is that not so? And that he's authorized to take confessions.
Correct, my lord.
You say he's not a Justice of the Peace and he's not authorized to take confessions. You can argue that. And if you succeed, the so-called confession which is taken by Mbodlo will be rendered inadmissible. Okay, let's make progress, please.
Thank you, my lord. My lord, let me just continue. Thank you, my lord. I'll argue further.
Because it also depends which university were you at.
It doesn't mean, it doesn't relate to university.
No, I'm saying sometimes they say you were not at Oxford.
No, I'm coming from Vista University.
Oh, right.
So wait. Yes, that's why I graduated.
So ithi isikolo somthetho asiphume sigcile kulolu daba ekuthi ulibele ukubuza ngawo ummeli ubuze imibuzo.
That's why I am going to discredit both Colonel Mboto and Colonel Rappert from taking confessions for both accused persons, accused number 1 and number 2. But let's move on. I just wanted to place it on record. Now, on the 30th of May 2020, accused number 1 is arrested just after lunchtime or during lunchtime, 1 o'clock or after 12:30. According to his version, he's taken to a place near a municipality area in Tembisa where he alleged that he was assaulted. I'm not intending to go back, but I just want to demonstrate something. Immediately after his arrest, he was taken to Fort Loras until he met you. When he met you, didn't have time to relax, didn't have time to think about his arrest. He didn't have time. His mental state at that time did not warrant for him to make a statement freely and voluntarily. Do you disagree with it? Because that confession was taken on the day in which he was arrested. Shortly after, he was maybe 4 to 5 hours difference.
Yeah. So, my lord, what I can say, obviously when he was arrested, I was not there. What I can testify about, and it's what I've said in my evidence in chief, when I spoke to him and gave him his right, when I met him for the first time, I did not see any signs of distress, someone who was in an uncomfortable position. I went even to an extent of asking the members who brought him to move away so that I can speak to him freely, voluntarily, and establish that he was not even under influence of alcohol or drugs. I did not detect such, and that version that he was assaulted was never told to me. Now that's the first part. Subsequent to that, my lord, we moved to the provincial office in Gauteng. He had time, he was not traveling with me in the car. It's about maybe 30 minutes or so from Postoras to that provincial office. He had time to think. And before I handed him over, when we arrived at the provincial office to the members of I asked him, I warned him and asked him if he was still willing to proceed freely and voluntarily, and he was, my lord. So the version that he was, things were done in a short period of time, that's not correct. That's not the impression he gave me. I spoke to him, he was free, comfortable in making these assertions freely and voluntarily. I cannot talk to what happened in Tembisa, but he did not tell me that he was assaulted, my lord.
Ngeyithethi ummangalelwa uma eqeda ukuboshwa uSibiya yena uye wathathwa wayisiwa eThembisa washawa futhi makazolethwa kuweke bekangazange athole ithuba lokuthi acabange akhululeke acabange nangokuthi sekaboshiwe uboshelwe ini kwenzakalani uthi ubrigadier ke mina uma efika kimi ngiye ngakhuluma naye futhi nalabo abamlethile ngabacela ukuthi baphume ukuze azokhululeka. Uma ngikhuluma naye ngiye ngambheka angibonanga izimpawu zokuthi lo muntu lo akakhululekanga, angibonanga izimpawu zokuthi lo muntu lo mhlawumbe kunenye into emhluphayo emqondweni, futhi angibonanga nezimpawu zokuthi wayekade eshayile. Naye uma ngikhuluma naye akazange angitshele ukuthi ushayile, ngoba ukusuka eFosloras ukuyofika eprovincial office labe ngikhona kuthatha mhlawumbe isikhathi esingaba imizuzu engamashumi amathathu. La ukuthi kuleso sikhathi sona isikhathi la ukuthi mhlawumbe wayekade engacabanga akhululeke bese azilungisa nokuthi uma ngifika lapha kwamele ngifike ngicebe labantu into yokuqala ukuthi bafike bangishaya.
All right. About with reference to the diary that you recorded, can you please take your diary, you open the records of the 30th of May 2020 and please read them on record in relation to what you have recorded.
Duty on, that is 0730, Phosphorus case 636 of 1/2014, departure to Ereton, and then at 14:10 got a report from Captain Yende and Mukula that the suspect Moses Sibiya has been arrested for the case of drug dealing and possession of unlicensed ammunition. I went to interview the suspect at Phosphorus around 1900 hours. The suspect implicated himself in the case after he was warned according to his rights. Colonel Mboto, I've mentioned his cell phone number, is requested to assist with the confession. He agreed. Says suspect must be brought to Diproof SAPS 30 May 2020, and then I've recorded just after midnight, 10 past 12, my lord. Colonel Mboto says he is done, and that I should come get the confession from his office, then 01:30 duty off.
Futhi uyafunda ke istatement eyena sibhale kwi-diary yakhe nge-30 zika May ukuthi kwenzakeleni uma ngisicaphula nje uthi ngalelo langa uye waziswa ukuthi usekaboshiwe uMoses Sibiya futhi kunezinto afuna ukuzikhuluma kulaye ukuthi naye uye wathatha inyathelo zokuthi ashayele uKolonel Mboto ucingo amtshela ukuthi uzocela ukuthi amsize ngomuntu ofuna ukukhuluma indaba ezithize bese ke ntambama kulaye ukuthi uKolonel Mboto uye wamtshela ukuthi sekaqedile ngalesa statement yena bese wabhala nokuthi washayisa ngobani isikhathi.
When you explained the rights, I beg your pardon, you explained the rights to accused number 1, and you told him about, I wouldn't say you told him about the requirements of section 217, but what relates to saying something freely and voluntarily. I assume this is what you told him. Was that recorded in your diary?
No, my lord. I've recorded that I've warned him according to his constitutional right. That is Section 35 of Act 108 of 1996. Insofar as the issues of him making the confession freely and voluntarily, the officer who is going to take the confession, for example, whether, like in this instance when I was talking to him, you have to satisfy yourself that this person is talking to you freely and voluntarily and without any undue influence. It's a requirement that you must meet, and that person is not under intoxication substance. Then you move on. So there's no, you can't tell that person to say, satisfy me that you are not, I must satisfy myself. Based on the question, his composure, the way he talks to me, the type, if I see injuries, obviously it's a sign that something is wrong. If I feel that he's crying or he's sullen somewhere, it shows that something is not right. So you must satisfy yourself that this person before you indeed is talking to you freely and voluntarily.
Indaba yamalungelo uyibhalile phansi kwi-diary yakho njengoba uthi uye wamchazisela amalungelo uthi lokho angikubhalanga kodwa ngibhalile ukuthi ngiye ngamchazisela ukuthi unelungelo, unawonke amalungelo, futhi mina-ke kwamele mina nganeliseke ukuthi lo muntu engikhuluma naye ngempela uzimisele ukuthi akhulume engaphoqwanga, futhi akusukuthi yinto ekwamele ibhalwe phansi leyo, yinto ekwamele nawe uyibone ukuthi lo muntu lo nanoma ekhuluma nawe ekhululekile. Uma ingabe kunezimpawu zokuthi mhlawumbe uthusele uyathuka noma ubonakala kuumuntu engathi ufuna ukukhala noma kuumuntu oyikuthi ekade elimele, bekwamele ngime bese ngiyabuza ke ukuthi kwenzakeleni noma kwenzakalani ngalendlela seyikuthi ubonakala uziphatha ngayo.
Brigadier Gininda, with due respect, sir, you are a person of interest under the case number, under the case number 636, and you were investigating the matter, and the information that you gathered from what you allege accused number 1 told you, there's no reason for you not to be biased by saying you told him this, and if accused number 1 say he did not say this, obviously you will insist because you are the lead investigator in this case. So I'll argue at a later stage that your evidence is rational and I would say you are biased in any way from that evidence. What is expected of you, being the lead investigator in this matter, was not to keep him with you. The second reason why I'm saying this, the accused number 1 and number 2, at all various places where the alleged offenses were, alleged confessions were taken, were transported by your, I would say, people who were investigating in the same case. For instance, Sergeant Mkhano. I submit with due respect that that investigating officer, Sergeant Mkhano, was not supposed to be neither closer to these accused persons when they took a confession. Am I wrong, sir?
Yeah, well, we are wrong when you say I'm a person of interest. We can start there because my understanding of the person of interest is something different, my lord. So you're totally wrong. I'm not.
Sorry, a person of interest is a suspect.
It's a suspect.
Sorry, so that you can't understand what you're talking about.
May I correct myself?
No.
With my poor English.
That's what it means.
No, but I want to correct it because I can see. You see, if every time say it might be mistakenly said, but if it is interpreted like either the witness or whoever intends to.
Okay, fine.
To make
But
fool
that's
of
how I
myself.
understood.
But let me just withdraw that term or that word. It has been erroneously used.
Okay.
But no one must capitalize on that one. But if he says he is not of a person of interest is fine.
Okay.
You are the lead investigator and you have an interest in investigating this matter.
Yes, my lord, I agree. I'm the lead investigating officer. That is why I said, after realizing that both accused were obviously on different occasions were confessing, I adopted an approach of getting independent officers as part of the bad practice rule. That was the whole idea. That is why there's Colonel Mboto, and then later there's Lieutenant Colonel Rapad, and then Lieutenant Colonel Khatebe. That is the idea, my lord, because as the court has rightfully said, as a commissioned officer, I could have taken those confessions, but obviously because I've got knowledge, and as an investigating officer, when we are seized with a matter, is to prove that the crime was committed. So it will not be advisable that you do that because, you know, it's not the best practice way. But I adopted the approach that brings in people who are independent. That's what I've done.
Njengoba inkantolo bese seyishilo ukuthi benginayo imvume yokuthi mina ngingathatha lezo statement, kodwa ngoba ngingomunye wamaphoyisa aphenyayo noma iphoyisa eliphethe uphenyo lwalelicala, ingakho ngiye ngagcina seyukuthi ngifuna abanye oza kwethu abekade bezosiza ukuthi bathathe lezo statement, ngoba mina akwamelanga ukuthi ngibe nendima engiyidlalayo kulezo statement, ngoba kuzosuka kube ingathi mina kunento engifuna ukuyenza, kodwa ingakho mina ngiyengafuna ukubona ukuthi ngenze isiqiniseko sokuthi utholakala abanye abantu ukuthi abaphenyi kulelicala.
And also, my lord, when I said, because I want Mr. Mgomezulu to understand this part, when I was correcting the part of saying I'm not a person of interest, it's what I said yesterday. It is not meant, or day before yesterday, it's not meant as an insult. My understanding in that time, because we're in court, if I concede to that, I'm exactly creating that impression that I'm a person of interest. I'm saying it with greatest respect because for me, that's what it says. And I'm correcting it that that's not the case. It's not meant to undermine him, so you shouldn't take it in a bad way. It's how I understand it, and I feel it must just be corrected. It's just what it is, nothing more than that.
Uma ngithi mina anginayo indima engiyidlalayo kuleli cala, angisho ngokudelela kumnumzana uMngomezulu, ngisho ngokuthi ngibeke izinto zicace, akusukuthi angimhloniphi umnumzana uMngomezulu, angayithathi ngokuthi angimhloniphi ngese baMngomezulu.
Thank you, Brigadier Gininda. We're coming from far with you. Brigadier Gininda, there's one thing that I want to know before we proceed. Remember when you read an affidavit, I think at the beginning of this week, there's an affidavit that you read when you brought an application for J50. I'm not going to J50 per se. I'm saying, remember that affidavit?
Yes, I do remember.
I want to know that affidavit. There's something that bothers me in that affidavit about the family whom accused number one was posting. You remember?
Yes.
In KwaZulu-Natal.
Yes.
As a result, that led him to that investigation to follow up to his arrest. So my concern is that information came to you on the 23rd of October 2020 for the first time.
No.
Or it's something that you got it before you made the affidavit.
Excuse me, I didn't know you were still talking. No, I got it before I made the application, my lord. So the application, I was seized with that information, statements were in the docket, my lord, which we've disclosed as well.
Ngiyenze le affidavit le ebengiyifunda ngomsombuluko ngemva kokuthi bese sengithole ulwazi izinto lezo i-statement zikhona phakathi kwedokodo. Ile affidavit uyasho ubaba uMngomezulu ukuthi la umangalelo oqala yena wayekade eziqhenya ekhuluma nabanye abantu abathize bomndeni wakhe abase KZN.
So that those statements were obtained Was it before you took a confession or after you took a confession from accused number 1?
I know the one of Absalom Zungu, my lord, that I referred to, that clearly implicates accused 1 and 2, was taken before the confession was taken. I think it was taken the previous year. Confessions were taken in 2020. That statement, from my recollection, would have been in 2019, somewhere end of the year, November, December.
Statement iska Absolute Mzungu ngiyasikhumbula ukuthi sona sathathwa ngaphambi kokuthi abamangalelwa baye bayokunyuluka ngoba leso statement sayenzwa ngiyacabanga unyaka ka2019 uma soya emaphethelweni.
That means, in short, you had a prior knowledge prior to CBR talking to you or making such a statement to you in Force Loras. You already had a knowledge about
Yes,
such
I knew.
allegations.
I knew there were allegations. They were person of interest, my lord. Council will remember I've explained this, that the reason we focus on them is because there was this statement, there was information, there was this statement that we had which identifies them as being part of the perpetrators who killed Senzo Meyiwa. We did a cold case analysis around them. So when they were approached on various cases, yes, we were fully aware that there's allegation that they were involved in this matter, in the killing of Senzo Meyiwa.
Yebo ngalesikhathi ezebe eza umangalelwa wokuqala bese sengazi ukuthi vele yena uyingxenye yalabantu ukuthi babulala uSenzo Meyiwa ngoba ithe uma kufika istatement kula ukuthi siye sabhekisisa abantu ukuthi kukhulunywa ngabo kulezi statement themayeza bese senginalo lolo lwazi.
And if you remember very well, I'm not intending to take you back from where I started my cross-examination, but there are certain things that are really necessary that should be placed on record so that we all understand each other. You'll pardon me for that. But may I remind you that, remember when we spoke about Section 219 of the Criminal Procedure?
My lord, I was spoken to regarding Section 219. I didn't say it. I was asked to read Section 219, subsection 1, and then I think Mr. Ramsipil and then read Section 219. So that's how it came about.
Akusi mina ofundele nomthethosisekelo owaka 219 ngafundelwa njengoba bengade ngibuzwa imibuzo akusi mina ovele waqala wakhuluma ngawo.
One of the reasons for my argument for these confessions to be inadmissible, to be made inadmissible, relates to Section 219, in that just a general understanding to mean a person making a confession, that confession is only admissible against him, not against other people. Did you understand that section?
Yes,
the same way I understand it.
Yes, and I did say that, my lord. I did say my understanding of Section 219. It simply says the confession made by accused 1 is admissible insofar as is consent. You cannot say now it's admissible on accused 2, 3, and 4.
Well, actually, the law says the statement.
The statement, yes.
Yeah, it's a case of State versus Molini.
Correct, my lord.
Extracural statement, Fortune Gwenya.
Correct, my lord.
Thank you, sir.
Uyazi ukuthi lo mthetho owaka 219 uthi uma umuntu esanda kugonyuluka lokho akukhulumile kuamele kusetshenziswe mayelana naye hayi abanye abantu. Uthi yebo ingalendlela enami ngichaze ngakhona ukuthi akusuka ukuthi kwamele kusetshenziswe mayelana nalabo abanye ukuthi yena ukhuluma ngabo, kwamele kusetshenziswe kuye ukuthi uthi lezo zinto ziqondane naye hayi ukuthi ziqondane nalaba akhuluma ngabo.
And will I be right to say there is a supplementary affidavit or an additional affidavit that you have made other than the affidavit you used to bring the application for a J50? Is there any other affidavit that you have?
I've made numerous affidavits as the litigating office on the docket, my lord. Others are changed, so it's not just one or two. It's various affidavits on the docket, which we've disclosed to the defense as well.
Uyavumelana nami na ukuthi ikhona enye affidavit ewuyenzile ngaphandle kwale ebokade uyifunda la emalangeni uthi yebo ngenze ama affidavit ambalwa kuleli cala?
Yes. With the leave of the court, my lord, I would request it's not going to be a futile exercise.
Which exercise is that now?
Because no, I'm saying it's not going to be a futile exercise. I'm just asking the court's indulgence if a certain affidavit, but it does not contain the contents that were redacted.
You've got that affidavit.
To be read. It was made by Brigadier Gininda.
You have it in your possession.
Yes, ma'am.
Can't tell you how to defend your clients. If you want to use it, use it. If the law allows you.
I'm asking the court if I can ask him to read it, my lord. I want to ask Brigadier to read that affidavit.
Where's that affidavit, sir?
It's A227. I believe
What is exhibit what?
exhibit. It doesn't have an exhibit, my lord.
It must have.
Because last time you said the witness can just read if the affidavit was made by him.
Now, because this witness says all the affidavits, he finished you, or Mr. Baloyi finished you with those affidavits. Is that what you're saying?
That's what I'm saying, my lord. Absolutely.
That's what he's saying. You've
Yes,
got
that's what
all
I'm
the
saying.
affidavits.
That's correct, but I only
Okay.
request only that affidavit, not all. Only that
Okay,
affidavit
no
to be
problem.
read.
Mr. Baloyi, what's your view about that affidavit being read?
If we have no problems with that, my lord, if they want to put it on record.
Okay.
Ummeli ucela ukuthi ubrigadier afunde nayi affidavit yakhe mshushisi uthi akunankinga angaqhubeka.
Okay.
Is that the affidavit?
That's correct. Sorry.
Yeah, my lord. Yes, I can. It is A227.
A227.
My lord, I see it's 1 o'clock. I'm not sure if we can adjourn for lunch. Then we continue after lunch.
Okay, should we adjourn, Mr. Nisi?
Yes,
Confirmation.
Yes, Mr. Ngumezulu?
As a court case, man, before my Leonard friend reads,
Yes.
As the witness reads the statement in the report, I've indicated to my learned friend that there's a paragraph that relates to an investigation that is pending, and that paragraph should be omitted when the witness reads out his affidavit. Well, firstly, my lord, as I've just indicated, the investigation pertaining to that aspect of the affidavit is still ongoing. But secondly, we think it's unfair for a person or persons to hear their names be mentioned in court when they haven't been afforded the opportunity, when they haven't been firstly informed of that fact, and secondly afforded the opportunity to make representations as far as that aspect is concerned. We will then request, my lord, that is paragraph 3.5 of 3.6 of the statement, the entire paragraph.
Which statement? I don't know. I haven't seen the statement. Remember,
Yes.
you and the defense counsel refused me to see it.
Yes. Well,
So I don't know what you're talking about.
yes, my learned friend is on his feet, and I'm suppose he's going to have the statement proven. But that is the request that we want to make at this stage. Once the statement is proven,
Have you, sorry, have you spoken to your learned colleague?
yes, he signaled his intention to have that part read into the.
The very
to
part
the
you're saying it would be unfair for it to be
Yes.
publicized in the absence of having
Yes.
brought same to the attention of the person
Consent, yes.
concerned.
Indeed, my lord.
So, Mr. Ngumezulu, what's your view?
My lord, the reason why I oppose the request by the state is because I also researched and checked the legal position regarding to the statements that were disclosed to me. That was disclosed to me, which were the affidavits of the investigating officer. And the state has not indicated any objection. And when an order was, or when the witness was asked to read the statement, then he raised that objection.
Okay, so
But
which
I don't
statement
see-
is this? I don't know what you're talking about.
The statement is the statement of the investigating officer of Brigadier Gininda.
It's a statement by Brigadier
Brigadier,
Gininda.
yes. Not of the witness.
What does it concern?
My lord, it relates to the participants in the commission of the alleged offense, and it won't actually be open to the court to give an informed judgment if there are certain aspects that are claimed to be privileged or to be redacted without reasons. In this case, an affidavit has been made. It's almost the same affidavit as the one that Brigadier Gininda has read on record. It's an additional paragraphs.
Does it concern a trial within a trial?
It is, my lord. It is, but particularly on the subject of 219.
Mr. Baloi?
As a court, please, my lord, we maintain that this information is irrelevant as far as the trial within a trial is concerned. But over and above that, my lord, we feel that it will be unfair to any individual or individuals to hear their names mentioned in court without them having been warned, and without them having been afforded the opportunity to come and make their own representations. We submit, my lord, that in a constitutional dispensation as ours, this cannot be allowed, my lord. There are no advantage, or there's no advantage to be gained by placing this information on record, as far as my learned friend is
When you say
concerned.
by placing it on record, I hear you. You know what, I've been lax in applying the law because I'm told, you're interfering. I've allowed so much leeway, people bringing evidence which has got nothing to do with the concept of a trial within the trial. Are you with me? Because this is a circumscribed interlocutory application. It's circumscribed, trial within a trial. And once you have used that evidence within a trial within a trial, you may possibly not use it in the general trial. Mr. am I talking sense?
Yes, my lord.
But I've been lax. Mr. Gomezulu can tell you, he has gone to the Antarctic and it comes back. For instance, now we're starting again in the Antarctic. You remember the statement you read?
Yes.
Which now he says it reminds him of something which you say accused number 1 was boasting about.
Yes.
Now, I don't know what he wants to prove about this, but I don't want to stop you. You can do what you think you must do. But when I come to adjudicate the matter, I'll be guided by the dictates of a trial within a trial. But I can't stop you from doing that because I'm told I'm interfering.
Also good.
So go ahead, do what you think you want to prove, sir. I don't want to encumber or abridge your testimonial duties as prescribed by your instructions. Okay.
Nizokhumbula ngaphambi kokuthi siphume ummeli uMngomezulu wayekade ethe uBrigadier Gininda afunde istatement esithize. Manje uma sibuya umshushisi uyacela uthi kunengcenye zazo le statement acela ukuthi zingafundwa, akathi statement sonke singafundwa, uthi ingcenye ze statement zingafundwa ngoba kunamagama wabantu ayikuthi ayashiwo kuleso statement. Labo bantu ubona ukuthi izobakhinyebeza ngenxa yokuthi labo bantu abakatshelwa ukuthi kunamagama wabo kulezi statement, futhi abatshelwanga nokuthi nanamuhla kuzofundwa amagama wabo aphumele sobala. La ukuthi ubona ukuthi umshushisi ngeke iphathe labo bantu kahle, futhi nakuleli cala akusukuthi kunento ethize izoguquka ngemva kokuthi lawo magama ashiwo, kodwa ukuvikela labo bantu ngenxa yokuthi abaziswanga. Manje uyacela ukuthi yena leyo ngcenye yaleso statement ingafundwa. Ummeli wenu uthi yena ayifundwe, yena akabone kunenkinga nanoma labo bantu bangaziswanga. Inkantolo ithi ilibele yelule isandla ifuna ukuthi leli cala leli liqhubeke, kodwa kunenye indawo la ukuthi ilibele yenza izinto ngoba abameli bathi iyeka okunye okomthetho, kodwa manje inkantolo ibona ukuthi ingathi sekuzofikela la izogcina seyithi umthetho uthi akulandelelwe umthetho, ngoba sikulesi sigaba ese-trial within a trial sokuthi kunobufakazi obuthize obukhulunywa ngabo. Lobo bufakazi khona kulesi sigaba bungasetshenziswa noma umuntu angakhetha ukuthi angabusebenzisi icala mase selizoqhubeka sesikuleyana ebizwa i-trial.
Okay, so you're at liberty, Mr. Ngomezulu, to do what your duty intends you to do.
May I please ask the court, my lord, to
Yeah.
the court, the witness to read the affidavit.
Read?
To read the affidavit.
Are you not going to prove the statement?
No.
Oh, you must read it.
Yes.
Yes, Mr. Baloyi, what is the law? What does the law prescribe?
Well, my lord, the law is very clear that no statement can be used unless it has been proven. And that is the steps that my learned
Okay.
colleague should follow.
Let's hear Mr. Ngumezulu, you can start. You want him to read it, but
Just to read the statement, I want
by not laying down the
now,
legal
or the
Protocol.
the basis. Yeah? My lord,
because then it is not a sworn statement. You understand it?
it is a sworn statement.
No, it is sworn until. It is sworn.
May I
But
lay the-
until, wait. If you want it to get onto the record,
Yes.
then you've got a legal duty to prove that the law was complied with when the statement was made
Yes.
to be a sworn statement.
Correct.
Okay, fine. You can proceed.
Thank you. Sir, Brigadier Gininda, is it correct that you are the deponent of the statement A227?
That is correct, my lord.
Kuyiqiniso ukuthi wena obhale lesi statement uthi yebo iqiniso.
Is it correct that you actually read this? Sorry, you're the one who wrote the statement by yourself.
That is correct, my lord.
We osibhale ngokwakho uthi yebo yimi.
So did you read back the statement to the satisfaction of the contents that are contained therein?
No, I made a statement, my lord. It's my statement. I
Yes.
made it.
Usifundile le statement ngemva kokuthi usibhale uthi mina yimina ongisibhalile bekungena sidingo sokuthi ngisifunde.
Did you sign the statement
Correct, my lord.
Usayinile uthi yebo ngisayinile.
in the presence of the Commissioner of Oath?
That is correct, my lord.
Usayine ngaphambi komuntu obekade esichithiza istembu uthi yebo.
Is the statement binding in your conscience?
That is correct, my lord.
Leso statement isiphethene sihlangabezane nonembeza wakho uthi yebo.
So do you correct the truthfulness of that statement?
Yes, I do, my lord.
Leso statement isiyiqiniso uthi yebo.
The date in which you signed the statement?
It was 20 November 2020, my lord.
Usayine nini uthi ngeyi-20 zika November 2020.
Thank you, my lord. I beg leave for the witness to read the statement
Yes.
on record.
Okay, sir.
Cela ukuthi asifunde uyafunda ke uBrigadier Gininda.
My lord, it reads as follows. I, the undersigned Bongani Nicholas Gininda, state under oath as follows in English. I am employed as a police officer in terms of Section 30 of the South African Police Service Act 68 of 1995. I perform my duties under the same act. I am currently stationed at the National Commissioner's Office as the commander of the Cold Case Investigation Unit of the National Commissioner with the rank of a colonel. I've mentioned the service number, my lord, and the telephone number, which I would like to skip. Paragraph 2, I am the lead investigating officer of Phosphorus case 636 of 10/2014, which is a case of murder where one Senzo Meyiwa was shot and killed on the 26th of October 2014 between 2030 and 2100 hours. This deceased was shot at the house belonging to then his girlfriend, namely Kenny Kumalo. It initially appeared that it was a robbery gone wrong. Witness statements under oath indicated that two black males entered the house demanding cell phones and money, purporting to be a house robbery. 7 adults and 1 child were present in the house when the accused entered. The witness stated that one of the suspects was carrying a firearm purporting to be a revolver. The accused was described as a black male with big eyes, dreadlocks, wearing a khaki or brown jacket or top and a hat. He was shorter in height than the second suspect. The second suspect was described as tall, slender, neatly shaven, and dark in complexion. It is stated under oath that during the robbery in the said house, a struggle ensued between Senzo Meyiwa, the deceased, and the suspect carrying the firearm. 2 shots were fired by the suspect. One of the gunshots hit the deceased, Senzo Meyiwa, on close range on his chest and exited at the back of his body. The second suspect, who is now accused 2, focused on the rest of the witnesses in the process. One cellular phone belonging to Miss Kelly Kumalo was robbed by the suspect during the committal of the offense. It is also stated under oath that suspicious suspects wearing specific clothing, among others a hoodie, were standing hidden away but only a few meters from the crime scene prior to the incident appearing to be typing on their cell phones. It is stated that the suspects fled on foot and the hat which was worn by the shooter was left on the crime scene. It is equally stated that the suspect hidden away, which is explained to be linked to the offense, was seen running away from the crime scene. Identikit was compiled through witnesses of this suspect. The victim was rushed to the hospital by the witnesses who were in the house. However, he was declared dead on arrival at the hospital. The incident took place between 20:30 and 2100 hours. The deceased was declared dead on arrival at the hospital at 21:15. Investigation further revealed, this paragraph 3, my lord. Investigation revealed that the cell phone which was robbed was picked up through cell phone towers until the signal was lost, covering the area of Phosphorus Hostel. The said cell phone was never recovered to date or ever switched on again. The evidence explained herein under oath indicates that the planning of the offense and gathering after the incident took place at Phosphorus Hostel. Investigation which resulted in evidence under oath revealed that the victim was murdered as a contractual assassination or hit rather than a robbery gone wrong. Evidence under oath revealed that 5 suspects actively participated in the planning and execution of the contractual murder of Senzo Meyiwa. The suspects are as follows. 3.1 Musika Ukhulelwa Thembas Biya. He was first linked to this offense by means of witnesses' statements under oath. The accused boasted to individuals closely associated with him in KZN Homeland as to his involvement together with Mafiga, herein under suspect 2, Carlos herein under suspect 3, Mapisa herein under suspect 4, and Nkani herein under suspect 5, into the killing of the deceased. A dispute ensued between these individuals, and the closely associated individuals disclosed to the SAPS the admissions these accused made to them. The accused was further linked with circumstantial evidence wherein he, minutes after the incident, made disclosures and remarks at a family gathering he attended in Phosphorus as to the killing of Senzo, even before the death was reported in the media. He is further linked by means of a formal confession he made to the commissioned independent officer on the 30th of May 2020. In this confession, he clearly implicates Ms. Kelly Kumalo as the person who gave them the instruction to kill Senzo Meyiwa. The suspect further made a formal pointing out the scene collection prior to the incident, the gathering of the outside of the house during the assassination, and the dropping off of the accused at the cell phone tower referred to herein above. The pointing out by this accused identified the exact scene, place, however, the scene, place, house where the deceased was shot. The accused identified the place, position he held when this offense was committed. In place in terms of his pointing out is accurate and meshes out the crime scene. The pointing out was made to another commissioned officer on the 6th of June 2020. Here, my lord, is the mistake. It should be the 5th of June, because that's when the pointing out was made.
Okay.
The accused was further linked by a witch doctor he attended prior and after the killing of Senzo Meyiwa. The said witch doctor's premises were identified by this accused. After the said doctor was found, the said doctor was taken to our offices for interview. It was during this movement in the office that the witch doctor came across this accused. The said doctor recognized accused in my presence and said he recalled also that he once came with Mapisa from Phosphorus to him but this accused denied the involvement of Mapisa and insisted to the witch doctor that he came only with the Buthelezi brothers. At this stage of the investigation, the presence of Mapisa is one of the suspect. The name of Mapisa is one of the suspects that was known to me, but it later became evident that this accused was hiding the presence of Mapisa to the police. The accused was initially confronted with the identikit of the suspect with the dreadlock as the person resembles his looks. The accused was formally warned according to his constitutional rights prior to the questioning. It was under these circumstances that he decided to make a confession, but clearly stating that he was not the shooter and that he was standing outside. He further indicated that Senzo was shot on the chest. He was confronted with this knowledge and how he know the exact spot of the wound if he did not do it or was not in the house. He then implicated one Marco Buthelezi as the shooter and the person who told him. He further said he was willing to make a confession and pointing out at the crime scene freely and voluntarily without any undue influence. 3.2 Bongani Sandisontanzi. He is linked to this offense by means of certified sworn statement he made to the witnesses and an identity kit complied through the description to the witnesses. He was identified as the person with the hoodie who initially stood outside of the house prior to the incident and running away after the incident. The involvement of this suspect was mentioned by suspect 1 herein above as equally involved in the killing of the deceased to the family of suspect 1. The suspect was traced through information received and was confronted with the evidence available against him. He was amongst others confronted with the clothes he was alleged to have worn and the compiled identikits. During the questioning and subsequent search of the premises where ammunition found for which no license was produced. The suspect was arrested for this offense. The accused was warned according to his constitutional rights and then interviewed about the suspicion that creates the belief that he was involved in the death of Senzo Meyiwa. The accused immediately said that he remembers that the incident took place on the 26th of October 2014 and that on that specific day he was at work in Rustenburg. I requested the accused to identify the said place of work, which he voluntarily identified. Upon proceeding and arriving at the premises of his previous employer, it was discovered through evidence obtained under oath that this accused lied about his whereabouts. In fact, he was on absent without leave from the 25th of October 2014 to the 3rd of November 2014. Hereafter, the suspect indicated his eagerness to confess as to his involvement in the matter. The suspect made a commission to a commissioned officer on the 19th of June 2020 and later made a further confession in the presence of his attorney to a magistrate in Boksburg Magistrate Court on the 24th of June 2020. Through the confession, does it appear that this suspect is the suspect that was described as tall, slender built, which came into the house. He also implicates Ms. Kelly Kumalo as the person who gave the order to kill Senzo Meyiwa. 3.3 Mtobisi Prince Mngube, nicknamed Carlos. He is linked by means of sworn certified statement in the docket referred to herein above. The involvement of this accused was equally explained in detail in the confession by suspect 2 above. Through investigation of this information contained in the confession, further evidence under oath was obtained as to the suspect's real name depicted above. It was established that the suspect was a sentenced prisoner serving 35 years in prison for the murder committed in 2015. Ballistic tests reveal that the same firearm used in the murder for which the accused was serving his sentence was used in the murder of Senzo Meyiwa. Upon the accused's arrest for the 2015 convicted murder, a cell phone was seized in his possession. The cell phone downloads of this cell phone were done. Photos found on his cell phone memory showed him wearing the same clothing that were identified by witnesses on the day of the incident as the accused carrying the revolver entering the house. Photos downloaded taken of the accused by him, selfies, during the day of the 26th October 2014 matched the description of the suspect who had the firearm with dreadlocks, big eyes and with gold teeth. This is the suspect that went into the house, made a demand for cell phone and money. He is also the same suspect that shot the deceased in this matter during the struggle with him. Evidence confirms that he is Zulu speaking. In fact, all accused in this matter are Zulu speaking and knows each other. Photos were equally found of the murder weapon used in the murder of Senzo Meyiwa. A photo containing the exact bag of money similar to the one found in Miss Kelly Kumalo was found. There is also another selfie that was taken by the cell phone of this accused, which shows him having a gold teeth. The gold tooth was one of the things that was noted by the witnesses. It is imperative to mention that this accused currently does not have the gold tooth as well as the dreadlocks, but evidence shows that he had both in 2014, October 26. Mthokoziseni Zipozonke Mapisa, also known as Mapisa. This suspect, this is 3.4 my lord, this suspect is linked to this offense by means of certified sworn statements and referred to herein above. He is further linked by means of a confession he made to a private person, a close friend, about his involvement in this matter. The confession came about in that this suspect requested this private person to establish the reason why suspect Mafika was arrested. The information disclosed was that the suspect Mafika was not only arrested for ammunition but also for the Meyiwa murder. Upon the private person return disclosing this information to suspect Mapisa, did Mapisa instruct the private person to return to and inform suspect Mafika not to disclose his Mapisa involvement, as he, Mafika, will be assassinated. It was during this discussion that the suspect Mapisa confessed to the private person his involvement in the matter. Investigation revealed that the role of this suspect was to guard any unexpected people who may come in or outside the house. He was also armed with a small firearm. 3.5 Sifokuhle Nkani Ntuli, also known as Nkani. The suspect is linked by means of a sworn statement by witnesses referred to above. He is linked to a car that was used as a getaway vehicle, which is a silver VW Polo with registration CT49YZGP before, during and after the murder of the deceased. Evidence also reveals that he drove the car with the suspect to the crime scene and back to Phosphorus Hostel after the incident. The accused is linked by cell phone analyst by means of a cell phone links to Miss Kelly Kumalo. His role was to remain and guard the getaway car during the commission of the offense. The confession of Mafika, insofar as the usage of the vehicle refers to, is supported by independent witnesses confirming that this accused was seen driving the vehicle prior to and after the committal of the offense in the company of the referred suspect above. The above suspects are also known as hitmen for taxi wars. The said suspects were traced and found on different locations and occasions where they were warned according to their constitutional rights in terms of Section 35/108 of 1996 by me and questioned for this incident. Some of the suspects made confession to independent commissioned officers as well as magistrate as indicated above. Others made confession as they were showing off to private persons who were well known to them after the incident, but on different occasions as well. Evidence on the cell phone analyst links him to Kelly Kumalo. 3.6 Nonhlanhla Kelly Khumalo. 4 cell phone numbers that she did not disclose to the police when this incident took place. These numbers were discovered by the XDS system used by the cell phone analyst and subsequently linked to her activities. The numbers are as follows: 079-494-4358, 073-451-5017, 073-886730, 061-456-2108. Investigation further revealed that she is linked to the actual perpetrators of this murder by means of cell phone linkages. These linkages connect her to accused 3 and 5. It was further discovered that through cell phone analysis, her cell phone memory album has the same photo of a see-through bag containing cash, notes, and in the exact position or location or spot of that of accused number 3. There is no reasonable explanation as to why Kelly Khumalo will be in contact telephonically with a headman or killers of a boyfriend and share the same picture of a bag full of money. Communication records between her and her sister shows that as early as 2013, she wanted to get rid of the deceased, as she puts it. It is apparently clear that she hated him and wanted to get rid of him. She further states that she regrets not succeeding to get rid of him before. Taking into account all these facts, an inference can be drawn that she meant killing him. Cell phone record shows that after the incident took place, she phoned a number of people from 082-703-4358 number, but no call was made to emergency services. She also subsequently went to the witch doctor for cleansing, as was also done by the other accused in this matter. The statement of Mr. Mkhize, who is an expert in this matter, clearly indicates that this is not normally or how it should be done, especially if one is innocent. Evidence by means of a sworn, corroborating and independent witness's statement establish a causal link between the offenders and the offenses of murder, robbery and aggravating circumstances, possession of unlicensed firearm and unlawful possession of ammunition, and conspiracy to commit murder. Ms. Kelly Khumalo seems to be the trigger point of this murder. Then paragraph 5, my lord, which is the last one, is basically the oath, and I signed. It was commissioned on 2020 November the 20th.
Yeah, just one query before Mr. Ngomezulu starts. You read, you say there's a casual relationship. It's causal.
Causal relation. Thank
Please,
you, my lord.
because I understand a bit of English.
Thank you, my lord. Causal relationship.
Right.
Yes, sir. Sorry, my lord, there's one last page at the back which I didn't go to. It's basically a J50 application warrant which was not signed for Ms. Kelly Khumalo. So, because it forms
It is in the...
It's part of the statement.
Yeah, it's part of it. Okay, fine, I hear you. But I say it's in the link of exhibits.
Yes, my lord. I suppose. I wouldn't know.
Yeah, okay, fine. Yes, yes. Oh yeah, by the way, you've got to interpret.
As the court pleases. Lesi statement siyafana cishe naleziyana esifundweni ngomsombuluko. Lesi sihluka njengokuthi sifaka igama ukuthi umangalelo wokuqala uye washo ke ukuthi ubani umuntu obekade ethe bayobulala umnumzana uSenzo Meyiwa. La yikuthi umangalelo wokuqala uchaze ukuthi bekade bethunyelwe uKelly Khumalo eyikuthi uye obekade ebatshele ukuthi babulale uSenzo Meyiwa. Nomangalelo wesibini naye uma eqhubeka ngemva kokuthi sekaphunyuluka kulaye ukuthi uye wachaza naye ukuthi uKelly Khumalo uyena obekade ebatshele ukuthi bayobulala umnumzana uSenzo Meyiwa. Bese ke umangalelo wesithathu naye uyabandakaneka kulo lelicala leli la ukuthi yena umangalelo wesithathu uCarlos kuthiwa ubekade naye ekhulume nabanye abantu abathize labo bantu nabo bathathe istatement bafunga phambi kwamaphoyisa ukuthi lezi zinto abazishoyo kuyiqiniso futhi kuthiwa uCarlos kahle kahle nani nonke nikhuluma isiZulu futhi kuye kwashiwo ukuthi efonini kaCarlos kuye kwatholakala isithombe ebesikade sibonisa isikhwama esithize ebesibonakala sinemali ngaphakathi. Leso sithombe satholakala efonini yakhe uCarlos ukuthi ithe isikhathi masiqhubeka kuye kwatholakala nokuthi futhi efonini yakhe uKelly Khumalo wakade kunaso leso sithombe esifana ncamashi nalesiyana esikuyifoni yaka Carlos. Futhi ke umangalelwa wesine ke yena utholakele ngokuthi naye bekade ekhulume nomuntu othize, lo muntu wagcina sekambuza ukuthi manje akungichazisele kufike kanjani ukuthi umafika agcine seyikuthi uyaboshwa. Umaphisa wamthumela ke wathi awuke uye uyohlola ubuze imibuzo ethize. Ithe makabuya lo muntu lo ongakhulunywanga igama lakhe wathi yena ukhulumile nomafika, umafika umtshele ukuthi uboshwe leli yaqala. Futhi umaphisa wathumela lo yamuntu wathi hamba uyomtshela umaphisa ukuthi angakhulumi ukuthi kwenzakeleni, kuthunyelwe ubani, angalinge nje akhulume ngoba uzogcina naye sekabulawa. Umangalelwa wesihlanu yena ubandakanyiswa ngokuthi uyena obekade eshayela imoto bekade kuyinhlobo ye-VW iPolo, number plate yakhona CT79YZGP. wabonwa ayishayela ngaphambi kokuthi kwenzakale lesi sigameko. Nangemva kokuthi isigameko senzeke uye wabonwa ekade eshayela leyo moto. Futhi naye uye wacebisa ukuthi umafika angakhulumi ukuthi kwenzakeleni ngalesikhathi kuze bekubulawa umnumzana uSenzo Meyiwa. Kuthiwa ke abamangalelwa bonke bona baziwa ngeyinkabi ebezikade zinokubulala abantu uma kunezimpi zamathekisi. Kwacebiswa futhi umafika ukuthi angalinge akhulume, ecetshiswana futhi umangalelwa wesihlanu ukuthi angalinge akhulume ukuthi kwenzakeleni ngoba naye angagcina seyikuthi uyabulawa. Bufakazi bubonakalisile futhi ukuthi uKelly Khumalo naye uyabandakaniseka kuleli cala. Manje ke uKelly Khumalo yena kunamanombolo athize ayikuthi uye waxhumana nawo, kodwa kuthiwa umuntu omsulwa akwamelanga ukuthi ayenze kanjalo uma sekunecala sekunengozi evelile. Nawa amanombolo kuthiwa mane, nombolo yokuqala i079 494 4358, yesibini 073 451 5017, yesithathu 073 388 6730, eyokugcina 061 4562104. Lawo manombolo akushiwo ngokuthi awakabani, kodwa uyabonakala ukuthi uKelly Khumalo naye ubeke washo ukuthi ubekade ekhulumisene nabamangalelwa, ngoba kunala ukuthi ithombe nazo ziye zatholakala la umangalelwa wesithathu atholakele khona kukhulunywa ngalesa sithombe salesiya sikhwama lesibekade sinemali. Futhi uma kuqhutshekwa kuhlolwa i-cellphone yakaKelly Khumalo kuye kwabonakaliswa ukuthi inamba eyikuthi ubekade eyisebenzisa beku 0827044358, la ukuthi naye ke uye wagcina seyikuthi uya enyangeni eyozigeza, njengoba nabo abamangalelwa bebakade bayile enyangeni bayozigeza ngaphambi nangemva kokuthi kubulawe umnumzana uSenzo Meyiwa. Bufakazi buyabonakalisa kwi-statement eyikuthi umuntu uye waya emaphoyiseni yena wafunga ukuthi bekade kunecala lokubulala futhi necala lokubamba inkunzi kuhlonyiwe, nokuthi bekade kunecala lekubanjwa isibhamu ngendlela engekho emthethweni nezinhlamvu bezikade zingekho emthethweni ukuthi kuyobulawa umuntu. uKelly Khumalo kubonakala ingathi uyena umuntu oyikuthi uye wathumela lezi inkabi ukuthi ziye ziyokwenza leli cala ubrigadier ufungile naye ukuthi zonke lezi zinto ezibhalwe kulesi statement iqiniso futhi uthi nasi esinye kodwa lesi asizange sisayinwe bekade kuyincwadi ebekade ecela ukugunyazwa kokuboshwa kukaKelly Khumalo as the parties. Thank you.
Okay, thanks. Mr. Ngomezulu?
My Lord, thank as the court, please. May I request the statement to be handed in, my Lord?
Yes, yes. What will be the exhibit?
Exhibit ZZ.
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 We just want to remind one my learned friend that it refers to the confessions and the pointing outs which are the subject matter of this trial within a trial, and which might be to the detriment of the defense.
What do you say about the remark by Mr. Baloyi?
I have no response.
Hello?
I have no response, my Lord, to this.
What do you mean you have no response?
If he says to the detriment, the time has come to argue this matter.
No, he says there's a potential prejudice against the disclosure of this statement vis-a-vis your clients, accused 1 and 2. Is that what you're saying, Mr. Baloyi?
Indeed, my lord.
Right. So,
Yes.
I mean, I did say to you, you have veered off from the principles of a trial within a trial.
Yes.
So I don't want to circumscribe your cross-examination, whatever, but you have been forewarned. And now, even your learned colleague here is saying the disclosure of this statement may presage the contents of the alleged confessions. Are you with me?
I'm with you, my Lord.
Okay, so you are free to cross-examine.
Thank you.
Ummeli ucela ukuthi lesi statement sinikezelwe kwinkantolo njengobufakazi umshuthisi uyaphakama uthi ucelisa ummeli ukuthi lesi statement masinikezela kwinkantolo azi ukuthi singahle sifake abamangalelwa wokuqala nowesibili esimene esibucayi uma lesi statement sifakwa njengobufakazi kwinkantolo.
Okay.
Thank you. Court pleases, my Lord. The attached document at the back of the statement was not part of the document attached when you brought the application for a warrant of arrest.
I don't. Can I ask defense my lord to clarify the question? I don't follow.
I'm saying when you brought an application under section 43, the 23rd, if I'm not mistaken, October, the warrant of arrest, the J50, bearing the name Kelly Khumalo, was not part of the documents that we...
No, it wasn't, my lord. That statement was made in November, and the application for J50 for Kelly Khumalo was made at that stage, my lord, November 2020.
Le ncwadi ebe ucela ukugunyaza ukuboshwa kukaKelly Khumalo beyikade ikhona na ngalesa sikhathi wenza le statement cha le statement isiyenzwe ngo-2020 le ncwadi yona iyenzwe ngemva kwalokho.
Thank you. May I proceed to establish from your brigadier in terms of the discretion? Did you take any discretion to stay or not to apply for a warrant of arrest against Kelly Khumalo?
No, I did not, my lord. As I indicated, it was this case, this matter was a prosecutorial-driven investigation. Now, prior to the application of the warrants that was made on the 23rd of October 2020, I've indicated in my evidence in chief that I made presentations, or not presentation, a memorandum to the DPP the not hurting one, where I indicated all the evidence that we have on all implicated people, including Ms. Kelly Kumalo. She is there. A decision was taken at that time that these are the people that must be indicted, and that is accused 1 to 5. I cannot disclose further details in terms of our discussion with the NPA, my lord, but there were certain things that needed to be looked into insofar as Ms. Kelly Kumalo. Then the following month, when we've covered some more grounds than then, that's when now I made a presentation again to say this is where we are and we're making this proposal.
When Brigadier uye wathatha isinqumo noma wacabanga ngokuthi mhlawumbe le ncwadi le ebunyaza ukuthi uKelly Khumalo aboshwe ingahle iqhubekiswe na uthi cha angizange mina ngiyenze kanjalo mina bengikade ngiphenya lecala kulibele kuphenywa yonke into futhi ithema kuqedwa kulayi ukuthi mina ngiyengaya kubaphathi babashushisi ngiyofaka isicelo sokuthi naba abamangalelwa ukuthi mina nginabo nginokufakazi nakubo ukubandakanyisa naye uKelly Khumalo la ukuthi ke bona abashushisi baye bathi naba abantu ukuthi bakwamele bashushiswe okwamanje njengoba kungakaqedwa uphenyo yena ubrigadier akazange athi akushushiswe labantu uKelly Khumalo yena aye.
In the light of the fact that of the evidence that accused number 2 made 2 confessions, one before Colonel Rapadu and the other one before Magistrate Mrs. Cronje. Was it also your discretion that it was not necessary for accused number 1 to be taken before another magistrate after he has made a confession or the alleged confession before Colonel Mboto?
No, my lord. I think I've explained this part. So the magistrate part for accused number 2 came as a result of a 105A communication between ourselves and the state prosecutors. That's how it kicked in. I was satisfied with the confession that was made because it missed the merit. It's a commission officer, he's a justice of the peace, there was a confession. Subsequent to us engaging with the attorney for accused number 2, and in discussion with the plea bargaining with the state, it flowed from them, and then there was this confession for accused number 2, which was not the case with accused number 1.
Awuzange ke ucabanga ukuthi ummangalelo oqala naye bebamele ayiswe ayoyenza ayogunyuluka phambi komantshi njengommangalelo wesibili. Uthi ngemva kokuthi bese sesikhulumisene nabashushisi kulayi ukuthi ummangalelo wesibili bese sesiyesathatha kwaxoxwa futhi njengoba bekayenze nalesi sicelo sokuthi yena kube ufakazi kugcine seyikuthi unikwa isigwebo esingaphansi. Ngemva kwalokho kulayi ukuthi siyesathi sanelisekile ukuthi ummangalelwa uqedile ugunyulukile bese kwathathwa ke nalesi sinqumo sabona ukuthi naso ummangalelwa woqala ubekade egunyuluke kumuntu onayo imvume yokuthi angalalela istatement esifana nazo lezo lo muntu ngikhuluma ngaye uKenneth.
Thank you, Brigadier. I'm well aware that such an engagement was done between the representative of accused number 2, as you say. But I just want to get into the point of accused number 2 being represented. The evidence, according to the state, is that the said person on the 24th of June 2020 was present when accused number 2 make a confession or the alleged confession. Secondly, the evidence that the state has is that the same attorney also participated in the plea bargaining agreement. And to the extent that such a decision or such a plea bargaining agreement was not concluded or finalized.
So,
The
must I
question,
comment?
yes,
What is the
I
question?
just wanted to ask a question. Throughout the involvement of Mr. Mchiako, the alleged Mr. Mchiako, firstly, before I proceed with the question, was the agreement concluded, the plea bargaining agreement, in terms of section 105, capital letter A?
My lord, yes, it was. So there was. It was not only Mr. Mchiako when the 105 capital A was involved. There was also another advocate who came on board. I mean, those are the issues that I didn't know because they form part of the discussions. And there was proposals and affirmations of standing with the confessions that were made by accused to the magistrate and Lieutenant Colonel Rappad. And the proposal of him testifying against his co-accused for a specific sentence, which we were of the view as the state that we are not happy with that sentence. The deadlock, it was concluded, because there's a formal communication, it was concluded the difference was on the proposed sentence from the defense side in terms of what accused 2 is prepared to do in relation. There was a specific sentence that is sent to us and said, I'm prepared to serve this sentence and in this manner, and then in return, I will testify against my co-accused, etc., etc. So it was formal and finalized.
Yebo bekuye kwaqedwa inkulumo phakathi kwabashushisi maphoyisa nommeli ummeli umjiyapha kusiyana yedwa khona omunye ummeli into bengikade ngingafuni ukuyiveza kodwa ngoba seyabuzwa nakho ke kwamele ngiyiveze ukuthi siye sahlulana nje uma sesekufika kwisigwebo lesi umangalelo wesibini wayekade ethe yena uzimisela ukuthi angasiya ejele noma ahlale endaweni ethize noma ahlale kanjani leso sigwebo leso kula siye sahlukana khona futhi umangalelo wesibini yena bekathe uzimisela ukuthi angayenza leso sigwebo bese uyabuya abe ufakazi wombuso afakaze kulento ukuthi abamangalelwa abane laba abanye bayenzile kulo lecala.
My lord, it's also prudent to mention that in this communication, I remember one document, he clearly admits that he stands with the 2 confessions that he made. And these discussions, my lord, were taking place after the matter was enrolled. It was not discussion that took place before the first appearance on the 27th of October 2020. While the matter was going on, after the first appearance, second appearance, those discussions were taking place so that one can decide where he must be placed. That is why at some stage the court would have seen that in the occurrence book he spent also a lot of time in police stations because there was these discussions and it was put by I think on the first appearance. The request was made by him in court. Mr. Mchololo was there for accused 2 to be kept at the police station. It was because there were these part of discussions that were taking place confidentially.
Futhi le inkulumo lezi ziyenzakele leli cala liselingenile enkantolo akusukuthi beqalwa ukuthi abamangalelwa bavele enkantolo bese sekulibele bevile enkantolo ingakho umangalelo wesibini yena uNtanzi wayelibele ebekwe esitokisini samaphoyisa isikhathi esiningi futhi nommeli umshololo wayekade ekhona ngalesikhathi uNtanzi eyenza leso sicelo akusukuthi bavele bayicabangela ukuthi uNtanzi yena angafakwa nabanye esitokisini kungenxa yokuthi bekusakhulunyiswana.
Thank you.
Once again, we just want to sound a word of caution to my learned friend that in terms of section 105A, if there's a proposal, a 105A proposal, if it falls flat, reference may not be made to it in any other manner. But if he elects to elicit that information, he does so at his own peril.
Umshutshisi ucela ukucebisa ummeli uMngomezulu ukuthi le mvumelwano leyana noma le yankulumo akusiyinto ukuthi kungahle kudingidwe ngayo kodwa uma ingabe uyafuna ukuqhubeka lapho angahle ahlabele mgaqo.
Thank you, my lord. I'm not intending to get into the gist of.
Oh, you're not disputing it.
Now,
It's one matter to not intending to get into the gist of it.
not that I'm not disputing
Okay,
it. Not that I'm not disputing it. My, in fact, I'm concerned about the representative, the legal representative, or the mandate that Mr. Mjiako alleged to have been given by accused number 2 to represent him. That, according to you, Brigadier, is there any power of attorney that was furnished by Mr. Mjiako?
My lord, I don't think I have authority to ask him to show me the power of attorney. When I met him on the 23rd, the first time, 23rd of June, after I was informed that there's a gentleman who is saying he's an attorney for accused number 2. I don't know how they communicated. I went there, my instruction, and I've said this in evidence in chief, my lord, that I said they must allow him, despite the COVID regulation, because it was a legal visit. I arrived, he identified himself, gave me proof from the LPC, which I verified, and later we get a confirmation from people. Other than that, my lord, I don't think I could have taken it any further. I don't think I have authority to say, give me the power of attorney. All I wanted to know was to confirm when I arrived, if he was legally, if he was indeed an attorney, that was confirmed. And subsequent to the proceeding that followed, I was convinced he was an attorney, my lord, because like I said, he appeared numerous times on this matter from the time of its inception, and subsequently in Pukeng as well, my lord. And then thirdly, the discussions in terms of section 105 with the state and with the advocate that he appointed at that time, my lord.
You don't want to disclose the advocate?
I know the surname was Butelezi, my lord. I remember the surname was advocate Butelezi.
Okay.
Uthi ke wena ke brigadier ubona ukuthi ummeli lo umjiyakho wayekade enalo ilungelo na lokumela umangalelo wesibini. Uthi mina anginalo lelo gunya lokuthi ngimbuza ukuthi unalo ilungelo. Ngitshelwe ukuthi kuthwa uthi uzomela uNtanzi ngathi abamvumele ngenxa yokuthi bekunale labhubhane lo COVID-19, ngathi abamvumele. Nami the mangifika wanginika ke incwadi ebonisayo ukuthi buya khona kubaphathi bama lawyer, waphinda futhi ngambona futhi nasenkantolo kulo leli cala leli, futhi nasePhukeng ngambona, nangokho bekungasuyena yedwa. Lo munye owesibini angilazi igama lakhe, ngazi nje isibongo sakhe kwakade kungowakaButhelezi.
Lastly, my lord, also I've indicated that on the 23rd, as I was approaching when I arrived at the police station, it is accused number 2 who first stood up and said, this is my attorney to me. Secondly, on the first appearance, because I was there, it was asked, accused 2 confirmed that he, Mr. Mjiako, is his legal representative. It's on record, it was televised, my lord, it's there.
Futhi ke enye into yesibili esemqoka uthi ithe yena mayifika lapha esiphoyiseni kulayo ukuthi umangalelo wesibini uyena watshela ubrigadier ukuthi nangu ummeli wami, futhi nayicala uma lingena enkantolo belikade liboniswa nakumabona kude umangalelo wesibini washo nakhona ukuthi ummeli wakhe uyena umjiyako.
Sir Brigadier, with due respect, if the court were to grant us leave to produce the clip, accused number 2, you were present, and he instructed me that when he was addressing the magistrate to the effect that I don't want this attorney, Mr. Mjiako responded, the presiding officer said, I can't listen to you if you are represented. Did you observe that, sir?
Not only, but that's not true, my lord. I was there, that's not true. Like I said, Mr. Msholo was there, the state advocate was there, a number of people were there, journalists were there. There is no way where accused 2 said in that the first appearance that he does not want Mr. Mjiako. That's absolutely not true. That's why even the request of where he must be incarcerated came through the attorney, Mr. Mjiako. And accused 2 moved with us for that incarceration during that time. So that is not correct, my lord.
Manje ke uthi ummeli uMngomezulu Brigadier akusiqiniso lento ewuyishoyo ngoba ngalesa sikhathi ummangalelwa evela enkantolo uye waphakamisa isandla wathi yena akafuni uMjiako kodwa uMantshi wathi ngeke ngikulalele wena Ntanzi ngoba unommeli nangokho ummangalelwa besisekathe yena akamfuni uMjiako futhi naye ummeli uMjiako uyena owaqhubeka efaka nalesi sicelo sokuthi ummangalelwa athathwe ahlaliswe endaweni yakhe eyedwa futhi uthi bebakhona aba umshushisi wayekhona uyaphinda futhi uthi nommeli uMshololo wayekade ekhona neintatheli zazikhona ngalelo langa ayikho lento yokuthi uMantshi wathi ngeke alalele uNtanzi ngoba enommeli uyakuchitha lokho ubrigadier.
Mr. Ngomezulu, I hear you saying you're thinking while there, no. Maybe it would be necessary for the clip to be played. Did I hear you correctly, sir?
That's correct, Madam.
No, but the law, does the law allow it? Remember, those proceedings were nullified. Now the question is, are you saying the proceedings in the regional court are not part and parcel of the subsequent proceedings which inured before my colleague?
My lord,
Let's listen to me because
yes.
you can think it's something simple. So if the proceedings start from the regional court,
Yes.
and then they are postponed in terms of section 72C to the High Court, those are the same proceedings. And when subsequently there's a plea and the proceedings before what's my colleague's name by the way? Right. Sorry, yeah, thanks. Mr. Judge Maumela, they proceed. And subsequently, through an order of this court, before I was appointed to take over the matter, they are nullified. Are you with me?
I'm with you, my lord.
Can you have the right to think aloud, like you are thinking, to say that tape of the first appearance in the regional court must be played? I don't think so. Me.
May I
What
be?
do you think?
May I be afforded an opportunity to
To check the law.
check the law, my lord? Then I'll make proper submissions. I'll be guessing.
Yeah, me, I'm certain the proceedings didn't be. That's why, for instance, section 337, you can quote the record of the regional court in the High Court. For instance, the bail application.
Yes.
When you argue bail application in the High Court, in the district court or the regional court, that evidence of the bail application is admissible in the High Court, meaning that, in my view, those are single proceedings which commenced when the accused were indicted and appeared in the regional court. What do you say, Mr. Baloyi? Let me hear your wisdom.
Well, our view is that the proceedings that were set aside are the proceedings that served before Judge Maumela, and the proceedings in the lower court, in the district form, stand separately from those proceedings in the High Court. In fact, the charge sheet was not even handed up at that stage. So it was only the indictment and the evidence that was laid before Judge Maumela that were set aside. The proceedings in the lower court did not form part of the proceedings in the High Court. The charge sheet was not handed up.
Okay, who wants to address this matter? Let's hear Ms. Mshololo. Any view?
My Lord, I confirm that the proceedings for the magistrate court did not form part of the proceedings which were before Judge Maumen.
Okay.
Therefore, we can still make references to that record.
Okay, Mr. Ngumalo.
Thank you, my lord. You can still make reference to that record.
Mr. Mnisi, you were the big prosecutor in the NPA. Formally.
I share the same sentiment.
With them.
Yes. Thank you.
Okay, me, I'm making a ruling that that is not so. They're the same proceedings. Go and check your law. The same accused were arraigned before a magistrate. In terms of section 72C, those proceedings before the magistrate under the same docket, under the same indictment which is subsequently drawn by the NPA, the Director of Public Prosecutions. They are superimposed and promoted, and continued before my colleague. That's why, for instance, anything that happened in the regional court, you can refer to it like Mr. Ngomezulu wants to say. For instance, if there was a dispute about the bail application, he said this, he didn't say that. The record of the proceedings in the regional court are applicable as evidence also in the High Court. Go and check section 337. Is that not so, Mr.? Is it 337?
That's correct.
Just quote it.
Yeah, well, as you mentioned, my lord, our view is that
Okay.
the proceedings in the High Court starts with the service of indictment in terms of section 144. So it's a completely new process that starts in the High Court. The Director of Public Prosecutions draws up an indictment as well as a written notice for the accused to appear in court. It's served on the accused in the lower court, and he then appears in the High Court on a new indictment, and the proceedings then commence in the High Court.
Okay, my ruling is that they are not. But if you, anybody who thinks I'm wrong, you can proceed as if they are part of what you say are the present proceedings. I don't want when it goes to the SCA, where there are several guys I've trained, they'll say, how will the judge do?
That's the court business.
Okay, so you can decide otherwise, but I'm making a ruling that they are not part and parcel. They are part and parcel of Maumela's proceedings. And those were set aside. Set aside. That's why when I came here, if you can recall, I said we are starting de novo, and you've got a right to apply for bail. You remember? I said that.
Yes.
Thank you. Yeah.
Indeed, but my lord,
Okay, no. Let's
yes. Yeah, just the final point that I want to make.
Yeah,
Because remember, the accused appears in the lower court, in the district court, before this magistrate, and at that stage, my lord, there were no problem. The magistrate there were no problems regarding those proceedings. The only proceedings in respect of which there was a problem, my lord, were the proceedings in the High Court, in respect of which, my lord, in our submission, the proceedings in the lower court did not form part.
Okay, fine. Yes, Mr.
With the guardians of the court, I don't intend to be long. But it is true that the proceedings that were before, I'm sorry to state here. It's true that the proceedings before the Honorable Judge Maumela were nullified. However, in this very same trial that we're busy with here, we continue to refer to charge sheets that came from the regional court. For instance, I refer the court to Exhibit E.
No, I agree with everything you're saying.
Yes.
Except that in law,
Yes.
all those proceedings were nullified. I even tried to say, look at section 337. What? You just read 337.
337, my lord, if I were to help.
Application that evidence in the lower court.
No, 337, my lord, has got to do with the estimation of an age of a person.
No, sorry, you're not 3.
Yes.
What's this 3? Just check that. Bail application, section 60.
It
And
should be
then-
around 60s. So.
No, but it's the transposition of proceedings in the regional court, making the bail application proceedings applicable in the High Court. You have it, sir? Got it.
Quick look. Yes, I'm aware of that provision that says
Read it.
the bail proceedings form part of the subsequent proceedings.
Yes.
I'm just looking for the relevant section. That is why the accused must be warned of that fact that the bail proceedings will form part of the subsequent.
Yes, you are right. You
proceedings.
see, now you're getting it. That's why, for instance, as you say, the magistrate in the regional court, when an accused brings a bail application, is obliged to warn that accused to say, be cognizant of the fact that when you're giving evidence regarding a bail application in this court, that evidence can be referred to and it is admissible in the High Court. Now, here comes the JP here, Judge Ledwaba. He sets aside the proceedings to which this statement that the bail application proceedings are admissible in the High Court, but those proceedings are set aside.
I found the relevant section, my lord.
What does it say?
Section 60.
What's the section?
11.
Section?
Section 60, 11B, subsection C.
Right, let's read
Says
it.
the record of the bail proceedings, excluding the information in paragraph A. Paragraph A refers to the
Yeah.
previous convictions
Yeah,
of
yeah,
the
fine.
accused. Shall form part of the record of the trial of the accused following upon such bail proceedings.
Thank you. Shall.
Yes.
Don't even have a choice. Shall form part of the trial. And which trial are they referring to?
Yes. Well, any subsequent trial.
Yeah, which was, in this case, it was who? Maumela,
Yes.
right? But Maumela's trial has been set aside. And
Yes.
in other words, you can't come and apply for a bail application, you,
Yes, but
Mr. Gumezulu, and then tell me that you addressed the court in the regional court,
yes.
okay?
But the section clearly speaks of the bail proceedings. There was no bail application
That's it.
in the lower court in this matter.
That's it. So what's your problem?
So our submission is that this section refers to the bail. If there was a bail application, those bail proceedings will form part of the proceedings.
Okay, fine. No,
in
fine.
subsequent
That's a good
proceedings.
exercise. And of course, it refers to the very same 5 accused who appeared in the regional court. The same proceedings, which are the same accused. They were arraigned in the regional court. Is that not so? Right. Okay, you have heard me. Let's move, please. Let's move. You say I'm wrong. Yeah.
I think my colleague is now being unfair
Of
when he says the section only refers to bail proceedings because it is
Not
him
fair.
who introduced these exhibits, the
That-
charge sheets,
it doesn't say so.
the charge sheets that are from the regional court. Then he must make an application to withdraw them
you're right.
if they are not applicable in this trial. Yes,
The charge sheet was served in the regional court.
yes.
Now, when I listen to you guys, the charge sheet was served before Maumela. No. They were indicted in the regional court. Is that not
Then the
so?
state must withdraw its charge sheet.
No, it's okay, fine.
Thank you.
Well, just to correct my learned friend,
Okay, let's
section
proceed.
235 was
Let's
missed.
proceed. You are saying what, and I'm saying the ruling is no. But because I can't stop you talking, you can keep arguing that way.
As a convict, but we use 235.
Okay, fine, no problem.
Le nkulumo ela ivele njengoba umnumzana uMngomezulu bekathi kungahle kudlalwe le ndaba uma uNtanzi ephakamisa isandla ethi akafuni ummeli umjiyapho. manje inkantolo ithi mnumzane Ngomezulu ucabanga ukuthi umthetho uyavuma na ukuthi lezi zinto ezisuliwe lezi bekuthi bezikade zixoxwa kuyicala uma inkosi yenkantolo kwakade ku-judge Mawume ucabanga ukuthi zingahle zisetshenzisiwe na manje njengoba leliyacala liye la suswa kwathiwa kuqalwe kabusha ingakho no Judge Mokgahleng mayengena uye wanicebisa enjela ukuthi nani namalungelo wokuthi ningafaka isicelo sokuthi nikhishwe ngebheyili ngoba icala liqala kabusha manje balibele badinga indaba umthetho lana oyikuthi uyakhuluma ngebheyili futhi bakhuluma nangama-charge sheet ebekade ekhishwe laphayana enkantolo engaphansi i-regional court manje ithi inkosi yenkantolo asiqhubeke ngoba ngeke siliqede lolu daba singahle silale la sivuke nakusasa siqhubeke.
Hayi mina ngiliqedile usho kanjani? Yeah, okay, it's an interesting thing, you know, because it's a question of interpretation, but it's not even that. Remember, Mr. Ngomezulu, I said we'll now start arguing about which university did you go to.
Yes, ma'am. I remember.
You can't nullify something which started. When was the first appearance?
27.
Of the
27
On the
October.
27 October.
Yes, 2020.
When the DJP, the DOWA was nullifying the proceedings before Mawume, he was wiping off the slate from the time these guys appeared in court. That is the nullity. Now, according to you guys, the nullity is just the High Court proceedings, and then the regional court proceedings are still current. Oh, madam. Okay, fine.
Just to mention, the proceedings were nullified not before the DJP but Judge Mo.
Yeah, sorry, yes. Okay, fine. Yes, Mr. Ngomezulu, Uzwile again.
Uzwile, ma'am. My Lord, I was going to request an adjournment.
What's the time now?
It's 3:20, ma'am.
3:20.
Yes.
I'll still continue with this witness, Brigadier.
It's only a few things.
So why don't we finish? If it's a few things.
It's an AVL, my Lord, Nchiako. AVL Nchiako.
Yes. Okay, fine. Maybe you'll have to come back tomorrow. I'll tell you why. You were saying the section 105A plea bargaining was completed. You heard yourself.
Yes,
It's an agreement, is that not so?
Correct.
Was it signed by both parties?
Insofar as I know, my Lord, but that was between
Was it signed by both parties? Even if, because of whatever you say, there are threats made to accused number 2,
Yes.
but it was signed.
My Lord, it was signed.
It was signed. Okay, that's all I wanted to know.
Yes, my Lord.
Yeah. And I'm sure the copy of that thing is somewhere.
There is a copy, like I've said, where I know the proposal
Okay, fine.
of these things that I'm talking about, and there's a signature.
All right.
So it was a formal engagement.
Okay, fine. Tomorrow then at 10.
Yeah,